Hypocrisy.
Hey, what's up, guys? Welcome to Laust Bulletz, the interwebs. I am your host, Nekieta of Nekieta Law, a small law firm in central Minnesota. And how are you guys doing? I am very, very glad to be here with you. We've got some stuff to do tonight, so that'll be fun. We've got oh my goodness, this hair. What is even happening? Oh, you know, what's weird about being a streamer, right? Is you stare at yourself every day for hours, just looking with your big, stupid fucking face right in the front of the screen, hours and hours and hours. So it's a mess. But anyway, I am here. We are here. We are going to watch the Kyle Rittenhouse motion hearing. I think it's going to be a two-part show on this because it's like 2 hours and 28 minutes. Let me get it pulled up for myself here. It's like 2 hours and 28 minutes for this thing. And or 2 hours and 18 minutes. And typically, you know, it takes me longer than an hour to get through an hour of live stream because we've got commentary, we've got discussion about what's going on. And so that, you know, it's going to take longer. So I'm planning to break it up. I also believe it is in two segments. I think we've got Bob, the prosecution's expert, testifying at this hearing. And I think we also have a matter before the court on how to describe the not victims of Kyle Rittenhouse, because the judge does not allow them to be described as victims in any case. Wish that judge were in Minnesota sometimes. But the rioters and looters, can they be called rioters and looters? Can they adequately be called that? And the people we're talking about, of course, are the corpses we're talking about are Joseph Rosenbaum and Anthony Huber, and the one-armed man we're talking about is Gage Grosskreutz. That guy's name is beyond me. So I do want to talk about that and see what's going on in this hearing. Like I said, I think those are the two matters before the court. There's something. So my microphone has a crosshatch pattern, a little wires, right? But there's something like between one of them, and it's throwing off my eyes. Anyway, very ADD today. We're going to talk. I think it's going to be in two segments. So I think it'll be adequate to break it up. So one of the things that we're going to also do tonight, so that everything is not so serious, we're going to watch. I've been doing this inception back and forth with Marshall, a guy who is married or in some way involved with Melinda Scott. Yes, Melinda Scott, who has sued Joshua Moon, the owner of Kiwi Farms and Kiwi Farms itself. And turns out that Melinda has issued a video response to me herself. And I was watching a little bit of it. It's not super long. It's like 10 minutes or so. And I think it's good. I think it's funny. I agree with her on everything. So I would like to, I think we should do that. I think we should watch Melinda's video to me, which I encourage people to make videos about me. I think they should do it. It's great. So I think that would be a fun sort of fun sort of break from the severity and seriousness of the Rittenhouse hearing. But before that, before we get started on the Rittenhouse hearing, because again, the way YouTube works is a bunch of you are here before the show, and then YouTube sends out notifications in weird ways, and some people pop in a little bit. So I'd like to open the show with some whiskey and a little story about today, because I didn't have the best day today. It was not fun. And I put that in the title, but I figure it's kind of lame if I just say, that, well, had kind of a lame day today, but don't, and put it in the title, but don't talk about it. So I was going to tell you about my day and kind of muse on some of my thoughts about it. And I know some enterprising individuals out there already know kind of what I'm talking about, because I've seen some stuff posted about it, and that's cool. Like that's great. People are looking and talking about it, but I figure I give you my input as well. So that yeah, that's what we'll do in just a moment. And then there's a super chat that came in before the show, but I'm going to wait to hit it until about 11:45, kind of around the time people peak at coming in to the show. That's when I'll hit it. Whoa, was I slowing down there for you guys? Because I'm slowing down for me every time I click on something, but it's probably just on my end. Excuse me. Oh, so I did go to the store today, and I got this Boondocks cask strength American whiskey straight from Kentucky, or maybe gay from Kentucky. I don't know. You never know anymore, right? But we don't judge. 118 proof, aged 11 years. Biden would be sniffing the ever-loving shit out of this bottle. But yeah, so I've got that tonight. It's going to be hopefully good. Oh, no! I'm sniffing it. Oh, God! It's a pretty neutral smell. A little... I mean, it's almost 60% alcohol. It's got a little beef to it. Oh, not bad. Some of these high proof alcohols, there's some people out there who they're like, oh, over 80 proof, you can't even taste it. It just burns your mouth. Stop it. Stop it. That's not true. This is 118 proof. Pretty smooth for being that heavy on the liquor. Not bad. Oh, and let me announce this at the beginning. Let me announce this in the beginning. There will be Twitch tonight. There will be Twitch tomorrow. Should be Twitch every night this week. I know I did not have a lot of time for Twitch last week. I felt really, really bad about that, but it feeds into today. So today was the final hearing in the case that I've had for the past 2 years. It's a criminal case, and it is today was sentencing, right? So my client pleaded, pleaded is the more proper form. My client pleaded guilty back in September to 5 counts of theft by swindle for a pretty large amount of money, an exceptionally large amount of money, and pled guilty. And the plea agreement is again, all this is filed, so this is all public. I'm not disclosing any private information for anybody who's wondering. But they The plea agreement was 49 months in prison. Long story short, 49 months in prison and restitution. So today, Minnesota has these sentencing guidelines, right? So they have a chart, and this chart determines what your presumptive sentence is. It's how this works. I don't know how other states do it. Some states have might still have fully discretionary sentencing. Some states might have more rigid. We use a guideline. It was created by a committee because at the end of the day, Minnesota is full of communists, so they do everything by committee. This committee takes into consideration a whole bunch of factors, and they create a grid. It's a really simple tool. And the grid says you take the severity of your offense, starting from like a 1, right? Like if you spit on someone, going all the way up to 11 for second-degree murder. First-degree murder doesn't have a severity level because it's just off the chart, right? But so you got a 1 to 11 on the left side on the y-axis, and the x-axis is it's the criminal history score, okay? And so your criminal history score, you match it up. It goes from 0 to 6, and you match it up with the severity level, and poof, it puts you in a box on a grid, and you have a presumptive sentence. Now, that presumptive sentence, you as a defendant have a right to that sentence, okay? You have a right to that sentence, as weird as that sounds. And if a judge wants to deviate from that sentence, up or down in any way, they have to, if they go outside of the bounds of the box, they have to justify their deviation. So Chauvin had this, right? Chauvin had the aggravating factors. He got an aggravated sentence. So based on his criminal history score of 0 at the time he's convicted, and then you take the severity level of second-degree murder, it puts it in the first box. But that's not very much time. I mean, it's more time than you want. But Chauvin got an aggravated sentence. So his sentence was doubled from the presumptive sentence because he had these aggravating factors. He had 4 of them. Well, in the same way as you have aggravating factors, you have mitigating factors as well. And those are all sorts of things. There's not actually an exhaustive list of mitigating factors, which means that there's not actually a good list at all. And the way this works in Minnesota is that it gives the trial court basically full discretion. The trial court judge gets to make this decision, and you aren't going to appeal it successfully 99.9% of the time. Because the trial court has all of the discretion. The trial court will make the findings, and then they will report those findings if they deviate. If they don't deviate, then they don't have to even make a finding on it, and you can't really appeal that. Almost all of the appeals on the subject actually have the appeals courts and the Supreme Courts affirming the decisions. There are a couple times where they get overturned. They're very, very rare, and they usually involve an upward departure where the judge says you get more time, and then the defendant appeals and goes, that's improper, and so then the later court will have to come in and reduce it. So it's this weird system, but it's what we've got. So the purpose of today's hearing was for me to try and get my client who had pled guilty and agreed to this 49 months in prison to keep my client out of it through an act of mercy and grace from the judge. Oh boy. The hard part about these downward departures is you can't justify the criminal act, right? Because if you could justify the criminal act, then you'd have a defense for the criminal act. It's literally, please, is your argument. But I've been writing and researching, a couple of the days where I didn't stream or I ended early. I mean, I've been working, researching and writing this motion to try and keep my client out of prison. And let's just say, well, It didn't happen today. Very, very unfortunate. And it's a frustrating thing. It's a frustrating part of being a defense attorney. And the hardest part, the hardest part, right? My client was guilty. My client pled guilty, admitted the facts of the crime. This isn't a question of whether they did it, if we could get them on some sort of technicality or something like that. That stage was over. So now we're just at asking the court for mercy and a sentencing hearing. So when you're in regular trial, as we'll discuss with Kyle Rittenhouse here, that's what they're trying to figure out, right? What's within the rules of evidence? What can we actually do respecting the rights of the defendant and making sure the state is acting properly? Once you get to sentencing in Minnesota, those rules into the garbage can. They go. The judge gets to how do I say this? Ignore whatever rule they want. There are no rules. They get to consider whatever factors. Evidence doesn't have to be admissible. It doesn't have to be true. The judge can come to conclusions that are not true, not based on anything, and completely unreasonable. I'll tell you one of them because this one made me a little bit angry. So we make the argument, right? This is how a sentencing hearing goes. The victims get to speak first. The victims get to make their statements about how this crime has impacted them. And then it goes to me to make my motion. So then I make my motion, give the oral argument. I've typed up a motion that the court already has. I have a bunch of letters of support for my client. And then you make the argument, right? And then the state gets to rebut your argument if you want, right? They get to respond. And then you get a brief chance to rebut whatever the state said, if you have anything. Very, very brief. And I just had to correct one bad assumption the state made, but that was okay. Their argument was, I mean, it's a sentencing hearing. You don't get to object that this is not admissible because that doesn't exist. There is no admissibility. Then the defendant gets to make their statement, right? And so that's the opportunity for the defendant to show remorse, to do all of these things. So, my client made their statement, and then the judge gets to talk. Well, so the judge, it was very quickly apparent that the judge was not going to do this. There was no argument that was going to happen. Again, my client confessed to stealing a vast sum of money. And it was devastating to the victims. I mean, that's the way crime works, right? Like, you do something, it harms someone. And this was a large amount of harm. The judge was not having it. Not at all. That's fine, right? You're asking the court for mercy. You're asking for leniency. There's no legal right to it. You make your claims, and the court does what they're going to do. And I'm not actually so mad about the judge's decision, but what the judge does next, and this is a problem with judges in general. The judge will then, in some cases, stand on a soapbox and tirade for a while about their moralisms to a defendant, right? And they'll say things that are not true, and they'll use that as justification for their actions. For example, today, the judge was barely holding back her trembling rage, and you could hear it in her voice. I'm not even kidding. As she asserted that my client was able to do this and to procure a privately paid attorney due to a reeking amount of privilege. Now, the interesting thing about that privately paid attorney bit, right, is as you guys know, as I've stated multiple times, I work pro bono. The judge never asked my client or me what my rate was, what I had billed my client so far. Didn't ask, just decided that because my client had exercised her Sixth Amendment right to an attorney and didn't ask the state to pay for it because of that, that was privilege, not a right. Not a right, not a fucking constitutional right to an attorney. In this case, one that was working pro bono. She exercised her right, innocent until proven guilty. Remember this. My client was not guilty until September. And had she paid a private attorney, had my client hired a private attorney, even with the stolen money, that would be legal. That would not just be legal. It would be her constitutional right to do so. Very interesting that a judge would use the exercise of a constitutional right. Now, the judge had already, make no mistake, the judge made up her mind. And the judge is well within her own rights to decide the way she ruled today. Fully within it, right? Within the guidelines. There's basically no way to challenge it. However, the moral grandstanding is what comes with power that judges have. And that is the thing that bothers me the absolute most, because while this judge is spending 10 minutes literally just berating a defendant, like there's no purpose to this, right? Like, you're about to send someone to prison. What moral lecture are you going to give? What does it even matter? You're not a priest. You're not a preacher. You're not a therapist. You're not anything. Although I will tell you that judges often delude themselves into thinking they are priests, preachers, psychiatrists, psychologists, sociologists, anthropologists. They will tell you everything about the human condition despite having no qualification to do so. It's just a lawyer, right? That's just a lawyer up there. The judge spent this time just berating my client and recited facts that were not true in the process. There's no objection you can make. There's nothing you can say. The judge is just going to say what the judge is going to say. The judge is going to make decisions based on whatever the judge wants, because that's how sentencing works. And it's just a shit thing. Look, I've known this client for a while, right? Been their lawyer for 2 years, if nothing else. But let me put it this way. Just this past week, the same county, right? I don't know if it was the same judge. The same county granted the same departure for roughly the same presumptive prison sentence for another defendant. This defendant was a guy who was caught drunk driving after beating his wife or girlfriend, I don't know, and child with a table leg. Same rough sentence, about 4 years. And yeah, that person didn't go to prison at all. That person got probation. That person is out. And there's no consistency to this. There's no check on it. But yeah, that's just how it goes, guys. It's a lovely system. Wonderful. Really, really tremendous. You should try it. You should try it. Go out there, you steal some money, steal a little bit of money, maybe have a couple sips of booze, get in your car, drive around, bash someone in with a table leg. It'll be fine. Wonderful. Just try it out. Try some different things. It could be great. Good experience for you. Nice life lessons. So so anyway, that's the root of my rough day. You know, it's rough for me. It's a lot rougher for my client and their family, obviously. You work hard with someone, you build a good relationship, and you develop like a, you're a confidant. They can tell you, as a lawyer, they can tell you anything, and you can't say what they've ever said. So you build up this kind of bond, and it's just frustrating. And then at the same time, right, you're in court, you hear how much damage was done to the victims, and it was a lot. I mean, that was hard to sit through. So that's why, you say, I can't be mad about the decision. I can't. My client still got, and the judge was sure to mention this. Oh, woo. The judge was sure to mention this one, that my client's plea deal was very good. Could have easily had a double or more time. Actually had to ask the prosecutor if that was correct. The prosecutor confirmed they could have gone for much more. I don't know. But, the decision is not the problem. It's not the frustrating part. It's to see a judge, and you want privilege. Be a white liberal woman judge in central Minnesota. You want privilege? You're wearing a robe that makes you immune to everything. And you're going to talk about privilege. Okay. All right. Tell me about the privilege of anybody else in this world. It'll be good. I'd love to hear it. Tell me about it. What big plight do you need to make up for? But yeah. So long story short, I put forth a valiant effort, and didn't go my way today. Was hoping it would, but it was a long shot. You're asking, to give you an idea, of all downward dispositional departures that are requested in Minnesota, 13% are granted. It's a rough hill. And when you have someone confessing to 5 different felony acts, severity level 6 felony acts, right? Remember, I told you it goes from 1 to 11. These are all severity level 6. When you have 5, you're charged with, I think at the end of the day, 47 felonies, something like that. I don't know. The number changed a couple times during the pendency of the hearing. They had to amend their pleadings a couple times. It was somewhere between 45 and 50 felonies. So, when you've got that record, and it's all electronic, man. Finances are electronic. I'll give everybody this legal advice. This is a very simple legal advice thing. Don't steal. Don't do it. The hard part about stealing is that a lot of times you get away with it, and then you do it again. And once it catches up to you, you'll wish you got caught the first time. You wish you got caught the first time. when it comes down to it at the end. But yeah, it doesn't matter, man. You never like coming out of a courthouse and not having your client with you. And I'll just tell you the hardest part of it, right? This is literally the worst part of it. Everybody thanks you. They thank you. You tried to help. You did what you could do. You stood up and defended them when no one else was going to. You worked on their case. You guided them through. You got them through a really tough time. They thank you. And it's like it's like this. It's like, let's say you're going to make someone a cake and you buy all the ingredients and you bake the cake. And then right when you're getting it to the place, you just dump it on the ground, right? Like you dump it on the ground, or a bird shits in the cake or whatever. And they're like, oh, well, thanks. It's sincere. They believe it. They mean it. And you just wish that you got a different result, right? But anyway, it's a mess. But that's lawyering. That's why I'm actually glad this case is done. I've been wanting to not have it looming over my head with deadlines and work for a little while. I get to take some time to not take a case, and I'm really looking forward to that. So that being said, that's my story of the day. We're going to hit some early super chats here, and then we will go ahead and get this Kyle Rittenhouse hearing started. Thank you for indulging me on my story. That's great. You guys get to be my therapist, right? Like, you guys have to put up with me, and I appreciate that you do. Hopefully, I tried to put in some legal education with it, telling about, how sentencing works in Minnesota. Look, I could actually bitch a lot about the hearing today, and just little things, but at the end of the day, we knew what we were up against. The judge had the discretion to make the decision. The judge made the decision. So, Rick Nekieta, are you behind the potato? Is that you? Did you do this? Did you do this, you motherfucker? Rick Nekieta, you asshole, did you do this? So, I get this box. It says, knock, knock, guess who? Right? I don't know if this is a Saw thing. Like, if I open this, if I'm going to be subject to murder or something like that. Anonymous Potato sent a present for you. I don't know why anyone would want to call themselves a potato, but thank you to the potato out there who sent this to me. It's got a potato sticker, and it also has a potato. And on the potato, it says, consistency is difficult, and so are math degrees. Yeah. Oh, shit. I didn't see the backside. It's got Vito's fucking face on it. Oh, that's good. That's a lot funnier than it was, because I hadn't actually pulled the potato out of the box. So I had only seen the words. I didn't see Vito. I didn't see this. That's hilarious. Oh my goodness. Oh, that's fantastic. Thank you. Thank you. That's good. You know what? I gotta say, I have a couple video clips from the biggest problem, the most recent episode of the biggest problem, or maybe the one before, I don't know, whatever, the one after the Chappelle thing, and I gotta say, Vito has an okay take in the clip, and then there's another clip where Dick has a less than okay take, in my opinion. But that's, that's fine. That's fine. It's Dick's subpar take is around this idea that I've talked about a lot, the never apologize idea, right? We know, you guys know about never apologize. It doesn't mean to literally never apologize. It means don't apologize to the mob that's demanding it, right? Dave Chappelle should not apologize to the pro-trans mob outside of Netflix. Netflix should not apologize to the pro-trans mob outside of Netflix. Vito made an apology about his actions regarding Friday Night Tights. And some people have accepted his apology, and other people have not accepted his apology based on what they think about Vito. Do they trust that the apology is genuine? And Dick said that the people who are not accepting the apology are the same people who say never apologize. That's not true, first of all. Second of all, there's no mob demanding Vito apologize. I mean, there might have been some people demanding an apology. I don't think anybody was saying, you need to say sorry, you fat fuck. I don't think that was the issue. The issue wasn't, we want an apology. The issue was, why are you such a bitch? That's the issue. Why are you flagging people? Why are you even doing this? You're being inconsistent with what you say. You say you support free speech, and yet here you are, routinely not supporting the ideas of free speech. That's the issue. No one said, you need to apologize or we're going to cancel you. That's different. The mob will cancel you after you apologize. That's why you don't apologize to the mob. That's what that's about. It has nothing to do with the apology. If you screw up and you sincerely think that you screwed up, then you apologize. Okay, fine. You apologize to the party you wronged. That's how apologies work. People do it all the time, and they're great. Apologies are wonderful. Dick's a big proponent of apologizing, even fake apologizing, because it makes the other person feel better or whatever. That's fine. That's separate. These are separate issues. Never apologize is a hyperbolic summary of the value of an apology to the outrage mob. The outrage mob doesn't want your apology. They even if they're demanding it, especially, they definitely don't want it. If they're demanding your apology, the moment you give it, they will use it against you further. That's the point of the outrage mob. That's why you don't apologize. That's why. Dave Chappelle, by the way, has not apologized, but he's offered an olive branch. He's done this stuff. Dave Chappelle is now getting canceled from film festivals on some documentary project. This is why you can't have any semblance. The end of The Closer is close to an apology for Sticks and Stones. Close. I wouldn't say it is. That's kind of the implication. Now, he does throw it back at him a little bit, but that's kind of the implication. I didn't mean to offend you. Don't apologize. You can't do it. Apologizing to the mob is unhelpful. It's unproductive. And so here's the ironic thing about Dick's subpar take is that well, the people saying don't apologize aren't accepting your apology. Well, let's take the extremist view and say the people who aren't accepting your apology are just extremists on the other side, right? They're on the right or whatever. They are the outrage mob. Okay? You can include me in that or whatever. It doesn't matter who it is. Let's say that's the idea. Well, why would they accept the apology if their mantra is don't ever apologize? That doesn't make sense. That's the consistent thing would be we're the outrage mob. We don't accept your apology either. That's the lesson of never apologize. It doesn't matter who the outrage mob is. Okay? The outrage mob is on the right, on the left, in the center. It doesn't matter who it is. Outrage mobs don't want an apology. It won't be profitable for you, so don't bother with it. If there's some people out there, though, who believe Vito's apology, I'm mixed on it. He said he went on an interview with some guy and got some new insight and has new perspective, and maybe he does. I frankly don't care what his insight or perspective or opinion is on the matter. I've stated my piece about Vito. At the time that he did this, he was not in any way in favor of free speech. He has a history of being against it, and he flaunted that history and said he would support it. If he's changed his mind, good. You didn't need to apologize to me. I don't care. I don't like you. I don't think your apology to the world and to the Friday Night Tights guys or whatever. I mean, maybe they care. I don't know. I'm not them. But it doesn't really matter. People are either going to believe you or they're not going to believe you based on how you conduct yourself. And you conducted yourself inconsistently. And so people don't really like that. They're not, just because you throw some words on Twitter doesn't mean people are suddenly going to trust what you've done. They need time. But that's okay. My focus on that, like I said, Vito's take where he said he's learning and growing and maybe his position is changing a little bit. Good. Great. Personal development. All for it. And I hope it does him well and he changes his position. I hope so. That being said, Vito's still a piece of shit. He's a giant piece of shit. He's been personally a piece of shit to me. More appropriately to my wife, who had nothing to do with anything. And that was, it's a little beyond, in my opinion, which is fine. He gets to say whatever he wants, but, I don't have to suck him off because he fucking apologized to other people. I don't care. And so fuck him. Hope he dies in a dumpster fire. Oh, well, these weird people. Well, I mean, he said a generic apology on Twitter to other people. Great. Cool. Have fun with it. That being said, yeah, I think Dick missed the script on the apology thing, but differences of opinion. That's fine. I've never hated someone for having a different opinion than me and never been mad at them. That's fine. People have different opinions than me all the time. In fact, I expect most people to have different opinions than me because I'm a weirdo. So that's that. Just wanted to say my piece in case people are wondering about it. I was going to load up the clips, but I don't know. Seems like a waste. I am thinking, so the anniversary of this show, which started November of 2017. Was it 2017? Either 2017 or 2018. November of, it had to be 2018. Oh my gosh, why am I so bad at this? Hold on, I'll tell you in just a second. I got to figure out when this was because it's going to drive me crazy if I don't. Oh my God, why isn't there just go to the end? I don't want to go. Do you know how many videos I've done over the years? I don't want to click through this. God damn it. 2017. Okay. Thank you. Yeah. So we're coming up on the 4-year anniversary of the channel. And I thought about, I'm thinking about doing this. I'm thinking about doing one video a day, one roughly 10-minute video a day on free speech, some free speech topic every day for a year. I thought that would be a fun project, and we'll see if I can possibly keep up with it. I thought that would be something that would be somewhat useful. Yeah, the first upload was November 16th of 2017. So yeah, I guess get ready. Here, and because I decided to do this and go all the way back to the end, here is a link to the first video that I've recorded as Ricketa Law. I mean, I had some like Diablo 3 videos and shit on the channel. They were just to share with friends. They like the channel was not a gaming channel or something. They're trash. It was like, oh, I need a place to upload a video so I can share it. This is the first actual video I did as Ricketa Law. It's maybe interesting to go back and watch. The ending is beautiful. It's classic, and made it onto Encyclopedia Dramatica and everything. So if you want to check that out, you can. There's a link to it that I've shared. But yeah, so November 16th, I'll finalize what's going on for the anniversary of the channel. But that's that. All right, let's get this show on the road. I rambled on way longer than I wanted. We got a super chat from Toyman99X. Shout out for Vic's meet and greet. Vic Mignogna, that is. People are asking if there is Vic news. Shout out for Vic's meet and greet on Saturday, October 30th at the Doubletree Hotel, 2780 Windy Ridge Parkway, Atlanta, Georgia, from 10 a.m. to 8 p.m., which I believe is during Anime Weekend Atlanta. Relic One, that was not my law office. I actually had a separate law office at the time. That was just the only room in the house that I was relegated to for computer space. So voice was so different. Oh, the mic was so different. The microphone was way different. Way different mic. Much different equipment. Anyway. Yeah, the background of those videos. Whoo! That was the room where, like, that was our storage room, and then I had a little section for me, and it wasn't much. And the rest, like, because I didn't need much, right? I just played video games. I didn't do anything over there. And so all of that shit in the background, like, shifts around, and there's a bunch of weird stuff. It was good. It was good. I was skinnier back then. That's true. Oh, yeah. I got to share this. I think this is during the same time as Anime Weekend Atlanta. What does this do? Woo! Look at that. It puts me in the corner. Cute. We've got Stan Dolan's tweet. Atlanta, Georgia. Vic Mignogna will be in town October 30th at the Doubletree Hotel, 2780 Windy Ridge Parkway, from 10 a.m. to 8 p.m. If you're coming from the Galleria, please use the pedestrian bridge for easy access. Outside that area, please use the yellow parking deck next to the hotel. Like I said, I believe it's during Anime Weekend Atlanta and the World Series. So make sure, if you're in Atlanta, God help you, but also go visit Vic. Go do that. Robert Barnes. Hey, what's up, buddy? We're about to go through Kyle's hearing, actually. We're about to watch, at least start it. We'll probably get about halfway through. We're about to start that up. So welcome. Glad to see you there in chat. Much more glad to see you than Attorney Tom there in chat. I like the Spike Man. Says, hey, thanks for picking up what Nux brought up on Twitter. It might be worse than we thought. I hope you are keeping up. What did Nux bring up on Twitter? Is that the where he got a strike, but he got it fixed? Brutally honest, Canuckastani says, here's some coin to cover your pro bono rant. That is nuts. What is that saying about when you assume something? Yeah. Yeah. Oh, so the cap of the story, right? After everything was done, oh wait, I told you. I mentioned to the judge off the record. I think maybe I didn't tell you. When she came back in for the next case, and I was just packing up, I turned to her and I said, hey, Judge, I just wanted to let you know off the record that my client didn't pay me a dime. I took the case pro bono. The look on her face was worth it a little bit. Because she knew exactly what I was saying right there. But she said, well, thanks for that. And then I left. Danny says, gonna walk Drex's point back on old man judges. If you get a woman judge, 50-50 chance she's a Karen and you're screwed. No, Drex's point was you want a female family court judge as a man. That was his point. That's his opinion. I've had a mixed bag. But yeah, this judge has some had some issues with my client today. Blaine 20 says, is there any point in appealing the sentencing? No, not really. They're almost never overturned. And considering the judge followed the guidelines, it's not going to be overturned at all. There's like no way. Uncivil Law says, Rekieta Law, you were fighting an impossible fight. You did everything you can. And in the face of certain death, you should be proud of yourself. You fought the good fight with everything you had. Hey, thanks, buddy. I really do appreciate it. I really do. I mean, that's how lawyering goes. Sometimes you can only do so much. So, but I appreciate that. And also appreciate you being a member for 6 months at the super lawyer level. Thank you. Very cool. Johnny Olson says, if Vito was truly remorseful, he would do something to stop looking so physically repulsive. Hey, Johnny, how you doing, buddy? It's been a long time since we talked. I hope everything's going well for you, man. Malik says, funny thing, they equate some of us to the purple hair people. Problem is, Vito isn't getting canceled from anything. We aren't going to his business partners or chasing him. We're just telling him to feck you when he shows up. Yeah, that's the thing. Someone's like, you're canceling Vito right now. I was like, where? I don't want him in, I don't want him to leave the biggest problem. I don't want people to stop their Patreons. I don't want anything like that. I've never called for that. I want people to watch the show and enjoy it if they enjoy it. But let's not pretend that this is some paragon of principle. He said he doesn't have any. Super Iron Bob says, I've made this mistake 22 times at least. Will I continue to? I don't know, man. It's up to you. It's up to you. Okay, let's do this. Should I be down here or should I do this way? Oh, God, you can't see the timestamp if I'm up here. Let me just switch to my headphones and then we'll be. I was having a problem with my other headphones, so I'm using these. I didn't share audio. We got to get that audio. There we go. Zara BP says, I just remembered I get a free chat once a month. Free. Definitely. Thanks, Zara. It is really appreciated. It is. Thank you. Okay, let's see. This is the guy, I guess. Here's the judge. I can't hear anything at all. Hold on. Let me see if there is audio on anything else. Let's see. What are we going to pick? Sekiro, but all the enemies are final boss.
I have got a good one for you today.
No audio? What the? Hold on. Aha! Got it. Got it. Okay, here we go. Let me start this back up. Oh. Back to 0. There we go. I don't know who sent the tater. It came from an anonymous potato. What? How do you not have audio? Fucking hell. He's not saying, he's just talking about the jury. I don't know what happened with the sound. I didn't change anything. That's the thing. I did not change anything. Let's see if this works.
12 in the box, 8 on that side, and 2 on this side. So that is 22. And then these tables are going to be moved, and we're going to line up 6 and 6. Is that 12? That's 30. That's more than we need.
That's 20 right there.
It's 22 because we're going to have seats on the side there.
Oh, okay.
And then if that works, hopefully, and then so then we need to get to 34. So there'd be 12 more.
So the problem was his audio was cutting in and out, and you guys are on a delay, so that's why it took a bit to fix. Gosh, there's no monitor for me. That's the thing. Like if I opened a tab to listen in, it would echo because it would be playing back the audio of myself. So there's no monitor. So I have to rely on you. And hey, you guys lie to me all the time. You made this. If I could trust you, this would be an easier thing. We could resolve this much quicker. But no, you guys are like, he's muted. When I'm not muted. You guys are liars. Fatal System Error says, probably my first and last free chat. Didn't even know this was a thing until now. It just happened like a month or two ago. David Friesner says, hey, Nick, I'm back at the beginning, but I had to chat because what you said pissed me off. Screw that judge. You are a good dude. Hey, thanks. I appreciate that. Arlanius says, at this point, if Kyle doesn't walk, dead legal system. I think Kyle, I'm hopeful on this. I really am. I think Kyle's got a great team and a great chance.
There until we start the trial, in which case we'll have 20 jurors, which we can accommodate in the regular space. So just so you're aware.
Are we going to get a chart, or are we going to have to make our own chart?
You'll get a chart, which, no, you won't. Not with 30, that's true. You won't get a chart with 30, so.
But so where will one be, in the far back corner? Okay.
So
Digitalis member chats have not existed as long as memberships.
Across the back.
That's not actually true. That's a new feature.
Yep.
And so
I know because they told me it's
here,
a new feature.
And then say 12 or 13 here going back. Got it.
Okay. All right. This is the case of the state against Kyle H. Rittenhouse. And
here we go.
Please.
The state appears by Assistant District Attorneys Thomas Bing.
I want to point out again, a lot of people. You get both mixes on Kyle's case. You get some people who are really amped up and think Kyle's gonna sail through. I don't know about sail through, but I put myself in the optimistic category here. And you got people who are real doom and gloom about the legal system, and they think that Kyle's being made a political statement. And make no mistake, his prosecution is a political statement. But they think that will translate through to the judge and the jury, and that what will happen to Kyle is he will be a martyr. He will be made into a martyr by politics. And that's certainly possible. But I do want to say that I think Mark Richards has acted very competently this entire time. His co-counsel, whose name I don't remember, has been overwhelmingly competent as well. Kyle appears to have a great team in the courtroom. We know that Robert Barnes is also involved, or maybe you don't know, but Robert Barnes is also involved in this case on the public relations side of it, and he's a good guy to have on the team. And I think he's indicated that that the jury selection team for Kyle Rittenhouse is very robust and includes people outside of attorneys as experts doing what they need to do. And a quick review of what they need to do is they need to have a social media team that can look up information on these jurors as fast as possible to make decisions about them. They need to have I believe they're going to have behavioral experts, like body language experts, will be analyzing not just what these jurors say, but how they react to the questions that are asked and how they react and act while they're answering those questions. And Free Kyle USA is the Twitter account that you want to follow if you want updates on how that's going. Free Kyle USA is also the aggregator of the funds, I believe. Don't quote me on that. Maybe they just have a link to where the funds go or something like that. But they sometimes disseminate some good information on their Twitter account. So Free Kyle USA, if you want to keep updated on this case as it goes. It's going to be starting up this next month, and I do intend to cover as much of it as possible. Hopefully all of it, but sometimes life might intervene. But I just want to say that so far, what I've seen from the team in the courtroom, my personal opinions of Robert Barnes and his ability to do some of the stuff on the PR side and his involvement gives me some hope for good outcome for Kyle. He could do much worse, right? He could still have John Pierce.
Singer and James Krause.
Good afternoon, Your Honor. Mr. Rittenhouse appears by attorney Mark Richards, Corey Shirafasi, and Natalie Wisco.
200 Watt Studio demanded that I pause the stream, so I will happily oblige 200 Watt Studio's request, and I will read. Printer God says, praying for the privilege to have a free chat, or paying for the privilege to have a free chat. Yay! And Adafo says, Nick, this is off topic, but I was hit with a forklift at work. 7 weeks later, 2 bulge discs, 2 abyssal fissures, and 1 week of physical therapy, and I'm still hurt. Any good lawyers in the Oklahoma or Texas area you can recommend? Well, I mean, I know some Texas lawyers. I don't know if they do work comp, but sounds like you have a very, very strong claim. Can you email me, Adafos? Email me, and I will reach out to see who can get some help for you, because that sounds like some stuff that you definitely need some assistance with.
All right, and it's here today for additional hearings, pretrial. And you want to start right away with the witness, or are 2 people in the waiting? Okay. Can you take it back? One of them is me. Uh-oh, that says unassigned. What does that mean? We lost. Now here we are.
You think I'm a boomer? Look at Bruce Schroeder over here, staring wistfully at the camera. Long pauses of dead air. Tonka, the judge, up here. Oh, my goodness.
They're all unassigned now. That's how they're showing up. And now they're disappearing on me.
Ho!
Close all rooms.
We got Dr. John Black.
Some people apparently got into rooms.
Chance Schofield says, who is the lady? Well, her name is Karen. I believe she's the stenographer.
Dr. Black, and I think...
Designation 5, Attorney Tom is an injury lawyer in Texas.
Can you activate your camera, Mr. Wills?
And he's someone who might be able to help. However, he does catastrophic personal injury, which usually involves paralysis, loss of limb, loss of life.
Well, I thought I had, but let me see.
Oh my gosh. These people are putting on a terrible show for us.
There we are.
Bob,
Good.
put on a suit.
All right.
Yeah, Bob.
So, all right, and then we have on the Zoom,
Oh, this unbalanced
have,
audio is killing me.
Dr. John Black, who testified last time, and Mr. Robert Willis, who will be testifying today. And this case is being live streamed on Decast at the Supreme Court
Random. Oh, no, that's
website.
prosecutor in the background. Gross.
Did you take it back?
Take what back?
I
Judge.
wanted to record it also. Not that there aren't.
Bob the Builder. Can we bury Kyle? Yes, we can. Remember, guys, that Bob the Builder sounds like he spent 8 days gargling razor blades and then washed them down with Clorox mixed with vodka. So I can't wait to listen to him talk. What? Just talk. Somebody talk. Oh, please. This is brutal. Yeah, what is Bob's logo doing down there? What is this? This might be something on the Law and Crime website. I don't know. Law and Crime's little logo's over here. They got their watermark. I don't know what the hell this is.
Well, in the meantime, there were a couple of additional motions filed.
Poopnatch, if I skip ahead,
and
I
I'll make a
won't
record.
know
About
where they talk.
6:02 this morning, a call came into the clerk, to which I have not listened, from a person whom the clerk advised me claims to be a witness, and we called IT, and they made copies of what was recorded, and it has been sent, I think, to both sides. So, and I haven't listened to it, and I just spoke with each of you, and I asked both, should I listen to it, and I was told by both it wasn't necessary. So that's where I'm going to leave it, unless directed otherwise.
If you are not in contact with an attorney in this case, either the prosecution or Richards, don't call the court. Don't call the court. You're not going to... Hi, I'm a witness in the Kyle Rittenhouse thing. I'd like to speak to the judge, please. Shut up. Just stop. I'm not going to switch the speed around when they are and aren't talking. Stop it. Stop it. You guys need to... Look, this is... When you're a lawyer, you're here because you want to be lawyers. Not true. Don't do that. When you're a lawyer, you have to suffer through this at every single hearing. It's not TV. In TV, they just get up and they talk and everybody's smooth and prepared. No. Just, you sit there waiting while being recorded. Everything you say, every move you make is recorded. Everything's recorded in court. And then you just sit there waiting for some judge or some other attorney or some witness to figure out what they're doing and talk. It's all waiting. Like now. Why aren't the attorneys on camera? Why isn't there a camera on the court, Bruce? We don't want to see you.
Thank you. In the meantime, why don't we take up this motion for a protective order regarding Officer Franco?
Oh, okay. Who's Officer Franco?
Is the motion opposed?
It is.
Okay. Mr. Binger?
Your Honor, I filed this motion regarding one of the witnesses that's been listed by the defense, Amanda Franco. The basis for this motion is that the officer here has virtually no connection to the case. The officer encountered the defendant on the evening of this incident, had a couple.
No connection to the case. The officer encountered this the defendant on the evening of the incident. Wait, it sounds like a connection to the case there, Binger.
Full of very brief and cordial conversations with him because she had recognized him from the incident from June of last year, which was the subject of our other acts motion. And the court has already ruled on that motion. The court has already ruled that the state is not going to be allowed to introduce evidence regarding that incident. And just to refresh the court's memory, that was an incident in which there's an allegation that the defendant's sister was involved in a one-on-one fight with another female.
Allegation. Saw the video. Kyle throwing bombs at that chick messing with his sister. Any good brother would do the same. No joke. If your sister gets in a fight, you should punch the shit out of whatever chick is hitting her.
And during that fight, the defendant intervened on behalf of his sister, essentially turning it into a two-on-one fight.
Hell yeah!
And I argued that it went to the issue of self-defense because the defendant was purportedly trying to assist his sister, but a two-on-one fight is hardly appropriate.
Oh, God, can you imagine how fun Binger is at parties? Well, a two-on-one fight is hardly appropriate. What the... Appropriate? Oh, well, yeah, you know, when I'm bashing someone's face in with my hands in the street and not in a ring with rules, I'm really concerned about what's appropriate. Oh, fuck off. This guy's only been on the losing end of fights his entire life.
This was recorded by some other individuals, and that video was submitted to the court as part of the motion. It's my understanding that after that video ended, there were subsequent interactions between the defendant and the individuals who made that video.
But, you know, we did go through this before.
Correct.
So get to the heart of your motion.
Certainly. The heart of my motion, Your Honor, is that the court has already ruled that that incident is not going to be introduced into evidence at the trial. The defense, by calling Officer Franco, I believe, would be seeking to relitigate that prior incident because, as I said, her only connection to this case is the fact that she recognized the defendant from taking a statement from him regarding that prior incident. And since the court has already excluded it as part of the state's case, I believe it's only fair that it be excluded as part of the defense case.
Thank you. Mr. Sharafsky.
Judge, I would never relitigate a motion that I've won. So I understand, having been a lawyer for a little bit, that if I open a door or I do something that would potentially bring something up that the court has already precluded, I guess I do that at my own risk. That's not the goal. I would never do that. It makes no sense based on what Mr. Binger has told you today that I would ever try to do that. But she is a witness. She was present during the incident. So if we believe, I've never had this before, where we believe that she may have relevant information as somebody that was present at the scene, that she be preemptory barred from testifying because they think that we're opening a door that I have no intention of opening. So I think it's only reasonable that the court allow her to testify if she has relevant information.
Yeah, real quick. I don't mean to cut off Sharifsi. He's 100% right. Like, this is an attenuated event. She's not coming to testify about that. And why would we be asking about that? She was there the day of the incident. She's a literal witness to the incident. Why would we preemptively bar her from speaking when she could have evidence, she could have facts or testimony that is probative to the incident? The June incident is not probative to what happened on the night that Kyle Rittenhouse cleaned up the streets of Kenosha. It's just not relevant. It has no legal relevance. It doesn't go to his state of mind. It doesn't go to his understanding of self-defense or whatever other bullshit Binger's trying to bring up so that he has an excuse to bring up a prior bad act, which would be excluded by the rules of evidence. What it does have, though, is a person who is witness to the defendant on the date of the incident. Now, if she saw him in the morning and then this is later, blocks away, and she wasn't there at all, I don't know. I don't know the extent of it, but she is, I mean, we're talking about a proximity in time and place that is far different from the June incident. It has nothing to do with what's going on. And if you notice, if you want to know the weakness of Binger's argument here, it's really simple. Well, they got what they wanted, so it's only fair, he said. I know you guys caught that because when someone says only fair, well, it's only fair. You know that kid, right? You know the kid who says, well, it's only fair if this happens. Yeah, sorry. It's not about fairness here. It's about what the rules of evidence are and what the laws are and what the rights of the defendant are. It's not about fair, and certainly not fair for the prosecution. If nothing else, the prosecution deserves unfairness. So that's what's going on. You can always look for weasel words and weasel arguments in prosecutor statements. First of all, you've caught me on a day when I'm particularly unamenable to prosecutors. But second of all, Binger has these tells all over the place. Well, it's only fair. Sorry, you don't get fair. You're a prosecutor. Your life is already, you're lawyering on easy mode. You don't deal with any of the shit that lawyers deal with, and you have the entire weight and resources of the state behind you, and you will be paid by the government no matter what you do. You don't have to deal with any of the complications of being an attorney. You don't have to collect money. You don't have to bill a client. You don't have to do any of that because you're salaried by a government with resources that are at your disposal, especially in a high-profile case like this. Lido Enchances says, these no-purpose flower need to get the ball rolling. Mither Nimmer says, hey, Judge, you ruled on this and said it wasn't coming in, but let me rehash the whole thing. Exactly. Bad move. Cool Frog says, with a K and 2 GGs, follow me everywhere. That's Cool Frog with a K and 2 GGs. All right, let's get back to this.
90401. And if it is, then she'd be allowed to testify about that. I have no interest in bringing up to relitigate something that has already been ruled in our favor.
Oh, yeah. Okay, sorry, I got mixed up.
Thank you. The motion actually seems to encompass not just the incident of July 1st, but also contact that allegedly was had between the accused and Officer Franco on the 25th of August. So I assume that if you wanted to get the evidence in on your initially as evidence of other crimes, wrongs, and acts, and I ruled against you, but if the defense wants to go into it, then you probably get your way and it'll come in. With respect to the incident,
what he's saying there is if she testifies and the defense goes into the other acts, then the prosecution would get their way. The interesting thing is the prosecution is barred from bringing up these other acts. But if the defense brings them up, or the defense is running the risk that the witness might bring up the other acts. So if and this is something that the defense has to consider. For example, if the defense asks a question like, so tell me about, so you, your name, you've been an officer for how long, you've been trained this way, blah, blah, blah. What's your relation to the city of Kenosha? How did you encounter the defendant on this day? And she's like, well, you know what? I saw the defendant and I remembered him from that fight back in June. You're like, whoa, shut your mouth. Then you run a risk. You could accidentally introduce this as the defense. If the defense is willing to take that risk, they can do so, but it doesn't mean the prosecution gets it in. But if the defense brings it up, or the defense's witness brings it up of her own volition during their primary examination of her, then certainly prosecution could raise the issues on cross. They could bring it up on cross and go after it. So that's up to the defense to decide how they want to handle it. And that's what the judge is saying here.
That allegedly occurred on the night that the shootings took place, then what is the reason that you think that I should suppress that?
Because it has no relevance. The report that Officer Franco submitted regarding her interactions with the defendant is very brief and simply says she had 2 brief but cordial interactions with the defendant after recognizing him from that prior report or from that prior incident. She would not have known him otherwise. She, I'm sure, was out on the streets that night encountering probably dozens, if not hundreds of people, some of whom she might have recognized, some of whom she'd probably never seen before. She only interacted with the defendant because she recognized him from that prior report. Otherwise, I doubt she would have had any interaction whatsoever. So I don't know what the relevance of this is, and I guess if the defense wants to introduce this evidence, I would ask that there be some sort of offer of proof as to what the relevancy is of it.
Judge, you got some feedback happening. Or is that
I apologize, everybody. What do you want for $50,000, right? But anyway.
If you want any evidence ever in your life that government is incompetent with every single thing you do, that court spent $50,000 for 720p webcams and trash microphones that don't work. Oh my God, look at the memeability of John Black's face there. I love that. Oh, what a great laugh that guy has. Mfer and Emrys says, bad move of the prosecutor to oppose a witness that could open door to a door the prosecutor wants open. FFS, one bad question by the defense, and the ADA gets the June incident in. This motion makes no sense coming in. That's correct. It makes no sense. Nothing. Why would he oppose this? Well, my question is, like, I know what I can guess what the defense is trying to do with this witness. She encountered him early in the day. It's probably about handing out water bottles and saying they were glad to have people around because they weren't really able to go into all the areas. I'm guessing that's what they want in. I'm guessing that's what the defense wants, is the sort of notion that the police were on the side of Kyle Rittenhouse, that almost, not quite, but that these interveners were almost deputized by the city of Kenosha. That's what the defense is going for. I'm guessing the interaction has some testimony that revolves around the fact that she was glad to see people there willing to stand up for it. But Mithrin is right, as I stated too. One wrong question, one wrong statement by the witness, and you go from talking about how happy the police were to have people on scene to an incident back in June where Kyle is punching a woman relentlessly, and that is, that's a risk that they might feel they need to take.
Judge, he's charged with multiple counts of reckless behavior, right? And so when we're...
And Robert Barnes just said, Binger just wanted to preview the cop's testimony. That's what Binger just said, right? Well, we think if they want to bring her in, we want an offer of proof. We want the defense to show what they intend to get out of this witness prior to trial. And so the idea would be to craft questioning around that, or to strategize around that, and to potentially strategize in how they could bring in the June incident.
When you are listening
Barnes.
to the evidence and the jury is making a determination as to whether or not that conduct is reckless, all the facts and circumstances for the jury instruction come into play. What he was doing, how he was doing it, how dangerous it was, the recognition of that danger, and him having contact with police officers that evening, them assessing that behavior, allowing him to move on with his night, certainly is relevant to his state of mind as it goes to whether or not that behavior was in fact reckless, as that is defined by the jury instruction.
So interesting question, and I don't know, but if Kyle is walking around Kenosha with an AR-15 on a harness, right, like he was later in the evening, and the cops see it and don't ticket him or ask him his age, I wonder why they don't, because it's obviously a crime, right? I've been told by Twitter so many times that it's obviously a criminal act for a 17-year-old in Wisconsin to be walking around with a long gun. I mean, if the police officer sees such a young face walking around with a long rifle, and it's a criminal act for a 17-year-old to be walking around with a rifle, surely a police officer, and maybe this is why the prosecution or the defense wants to bring it in, surely they would have said, hey, can I check your ID? Aren't you that kid? Can I check your ID on that? Surely someone would have said, oh my gosh, this is a horrific crime, but no one seemed to do that. But I don't know. I don't know if he had his rifle at the time. I'm not familiar with their meeting.
So it's relevant. And if it's not, Mr. Bringer can ask that it be stricken. You can take him up on that. But his contact and Mr. Rittenhouse's contact and what he's doing with law enforcement and the contacts he has with them, under the idea of whether that behavior is reckless or not, all of those contacts are relevant under the jury instruction.
I agree.
Simple as that.
I think I don't see any reason to anticipate trouble. I can understand that you might be apprehensive as to some misuse of some kind of testimony along this line, although I'm certainly not suggesting that I see misuse coming, but
this cop keeps dropping the judge keeps dropping the white power.
Contemporaneously object. I think that's probably the better way to handle it rather than for me to slam the door on them before even hearing what purpose they want to use it for.
Your Honor, this does tie into the motions in limine that I filed, and I appreciate Attorney Trossi making explicit what I have long suspected, which is that this is going to be a trial over the police department's activities that night. The argument...
No, it's not. I mean, for one thing, maybe it will be, but the police department activities are relevant, especially when they have contact with the defendant. Shut up, you whiny bitch. Barnes said every single cop that night saw Kyle armed and welcomed him, encouraged him, and thanked him. Of course they did. Of course they did. Because as Robert Barnes knows, as Sharifsi knows, as Binger knows, there's nothing weird about a 17-year-old having a rifle in Wisconsin. There is nothing strange about that. It's a state with a history of hunting. That's why in the exemption, in Section 3C of the statute, it specifically exempts out shotguns and rifles with standard length barrels. That's why they're the exemption. It's about handguns in Milwaukee. It's about handguns in Green Bay from bad actors, from gang members, from inner city. That is what it is. That's why they exempt out rifles and shotguns from dangerous weapons, but they include in literal nunchucks and brass knuckles. Like, it's about fighting and violence. It's not about and primarily about gang violence. That's the purpose of the statute. It has nothing to do with what Kyle was doing, which is far outside of the regular consideration of the statute. It's not a hunting thing. Sorry, it is a hunting thing because Wisconsin is such a strong hunting state, and it's not targeted at hunters, is what I was saying.
Here that was just put on the record is that the police saw the defendant that night, didn't stop him, and so therefore there's some culpability on their part, or some sort of implicit approval of his activities that night, or express approval of his activities that night. That's not relevant, Your Honor.
Implicit or express approval of police officers would absolutely factor in to a client's or to a defendant's state of mind in a self-defense situation. 1 billion%, 1 trillion%. Like, first of all, let's not forget that Binger has argued that Kyle getting into a fight months before the event plays into his state of mind about self-defense. And then further, he has argued that Kyle meeting up with the Proud Boys months after the event factors into Kyle's understanding of self-defense on the night of the event. Now he's going to argue that his contact with police officers that may have contained express approval of his activity is not relevant to his state of mind on self-defense. Duplicitous garbage.
Honor, the police assessment of the defendant prior to him killing two people does not have any bearing on whether or not his actions in shooting and killing two people were lawful or reckless or not.
But a fight months prior does. Idiocy.
The jury is the one who's going to make the ultimate determination there. And whether or not police officers saw.
Yes, and the jury has a right to know. The jury has to know how they would feel if they were Kyle walking around with an AR-15 in defensive businesses in his city, and police came up and said, "Hey, good job, keep it up, thanks for helping." They have to factor that into their question of would they, as the jury being the reasonable person, would they have pulled the trigger that night? That's the thing that Binger is so scared of, is that the closing argument of Mark Richards will say, well, imagine you're Kyle Rittenhouse walking the streets of Kenosha with your AR-15 and, you come up to some officers. Those officers say, hey, good job, Kyle. Glad you're here, Kyle. Walking around policing when we can't do it, Kyle. Thanks. Really glad. Hope you stay safe tonight. Hope you keep the businesses safe tonight. Just imagine you're in Kyle's shoes talking to the officers. And then, when it comes down to it, would you make the decision to pull the trigger on Joseph Rosenbaum, a giant pedophile running at you? That's what Richards is going to make in his closing argument. If he's got testimony from a bunch of cops saying, yeah, we were happy you were there. We told him we were happy. That's exactly what he's going to say. And by the way, I'm pretty sure that that's a pretty good Mark Richards impression. I don't know. Barnes will have to grade me on my Mark Richards impression.
Saw him earlier in the evening when he wasn't shooting and killing people, and whether or not they stopped him or didn't stop him or said anything to him or didn't say anything to him is not relevant to the ultimate decision in this case. But I think the defense argument here is pretty clear. They want to say that because police officers saw him and didn't stop him, somehow that makes him lawful, that makes him justified. And I don't think that's the case, because number one, that's not the determination here as a matter of law. But number two, the officers didn't see him shooting people. They didn't see him killing people. They saw him at a time in the evening when he was on private property guarding a building, a business. And that's
pretty relevant.
Different than the activities that are alleged to be reckless here.
You mean when he was on private property guarding a business? You mean that when he took the first shots while he was on private property guarding a business, that time? You think that's not relevant?
So I don't think there can be a connection here between what the officers may or may not have done earlier in the evening and whether or not the defendant's ultimate actions in shooting and killing two people were intentional or reckless or justified. So I think this is exactly where I thought that the defense would be going. It's one of the subjects of one of my motions in limine, Your Honor. It's, I believe, motion number 3, and it seeks to make sure.
Number 4.
I'm sorry, I've got it misnumbered. It's number 4, and that's part of my motion in limine here, which is that the defense should not be allowed to, actually, no, it's not number 4. It's number 5, actually. It's the motion in limine talks about whether or not anonymous law enforcement officers made statements earlier in the evening regarding the defendant's activities, or whether or not they're
not anonymous law officers, right? You're expressly trying to exclude a particular named non-anonymous law enforcement officer right now. They're not anonymous. They're asking to bring a non-anonymous officer in to testify.
They talked about their plans in terms of crowd control or things like that. And this is not a trial about the police activities. It's not a trial about police tactics. It's not a trial about whether or not law enforcement that night took action or didn't take action. This is a case about what the defendant did that night. And I'm concerned that this is going to be turned into a trial over what law enforcement should or shouldn't have done that night. And I don't think that's what this court or what this trial should be deciding.
Okay, that's incorrect. Binger, first of all, Barnes mentioned that Binger is misstating the defense's arguments, which is true. That's, prosecutor's going to prosecute, right? But at the same time, Binger's absolutely incorrect. The actions of the police, 1 billion% factor directly into the state of mind of someone acting in self-defense. Because guess what? If the police aren't going to come save you, your decision to pull a trigger is very different than it would be if the police are there. That goes direct. It's a question directly to the core of what is a reasonable person thinking about the need to defend themselves when they make the decision to shoot. Are the police coming? If the police are there, you might not shoot because 1, you might shoot a police officer. 2, you might think that they're going to protect you. In fact, they may be in the act of protecting you. But if there are no police there and you know they're not coming, you can't just keep running, because no matter how long you run, if you get tired, if you trip, if you fall, you will be attacked and there will not be a badge to save you. That goes directly to the defendant's state of mind in self-defense cases. This is nonsensical.
Oh, are we arguing the motions in limine now?
We are.
Okay, very well. So no, I guess we're just doing number 5 right now. Oh, I don't need it for this one. So
yeah,
I'm curious, by the way, that was an interesting reaction by the judge. He's like, are we arguing the motions in limine right now? The judge's like, yeah, we are. The judge has likely made up his mind on these motions already.
He says 4, you say 5. It's like Protestant versus Catholic with the 10 Commandments.
So, this is my understanding. So there is
okay, look, that's not as funny as me laughing at it merits, but I love that. That is the oldest man joke I've ever seen. You say 5, he says 4. It's like Protestants versus Catholics with the 10 Commandments. That is the oldest man joke I've ever heard, and it's triply funny for me. I like Bruce Schroeder. I really hope he does. He seems to be conducting a good trial so far. I hope it keeps up.
In the video, there is a statement by a police officer who says, an unidentified police officer saying, we appreciate you guys, we really do. Now, what Mr. Binger initially said is, that's hearsay. Now, we are obviously not offering it for the truth of the matter.
It's not hearsay. I would say right now, it is not.
It is not.
It is not hearsay. I don't want to spend a lot of time. We can discuss it again at the trial, but just to save time this afternoon, it's not hearsay.
Oh no, Binger got he just got blown out on that one. It's not hearsay. Look, we can discuss it again. I'm just gonna tell you now, no, this is not hearsay at all. It's hearsay. It's important. It's a statement heard by someone from someone else, used to prove the truth of what the statement says. So if they were offering it to prove that the police actually approved of the actions, that would be hearsay. But they're not. They're offering it to establish Kyle's state of mind. I assume they're offering to establish Kyle's state of mind when he is defending himself. And that actually is really relevant. And that's not a hearsay, because it's not about what the cops actually meant. It's what Kyle heard and internalized as his own present mental impression. And that's one of the easy ways a lot of times to get around a hearsay objection. What is the present impression and the effect of its mental state on the person who hears it, not about the truth or denial of what was said. And of course, it always helps to have the jury hear that the police approved of what they were doing. I mean, it's a nice end run around the hearsay objection, but there is a rational and legally relevant reason to introduce that statement because it goes directly to Kyle's state of mind.
I agree. So, and what I've laid out for the court, and I just want the state to understand this, that no one is saying that because the police, however they reacted, that Mr. Rittenhouse was lawful and justified. That is not a defense to a charge. But Mr. Binger has chosen to charge reckless conduct. Okay? He's made that decision. Now, he has to be able to show the defendant's conduct showed an utter disregard for human life. All I've done is looked at the jury instruction on what a fact finder is supposed to consider when making that determination, Your Honor. And if you look at that instruction, they are to consider what the defendant was doing, why he was engaged in that conduct, how dangerous that conduct was, how obvious the danger was, whether the conduct shows disregard for life, and all other facts and circumstances related to that conduct. And I would submit to you conversations, interactions that he has with law enforcement go to his state of mind as to whether or not, A, how obvious that danger was, and whether it was actually dangerous conduct.
Obviously.
Those are relevant factors to determine reckless behavior.
Extremely.
And when he has conversations with police officers and they let him go about his business, and when the police say things like they've said on that tape, those go to his state of mind. They are absolutely relevant for the charge of reckless. He is charged with 3 different counts of reckless behavior in this case. So the way that Mr. Binger has chosen to charge the case has opened up, in our view, has opened up the facts and circumstances surrounding what had happened, because the totality of the circumstances go into play in determining whether or not behavior is shows an utter disregard for human life. And that's what we're saying it was.
Now, the reason I said it isn't hearsay, and I don't want to get an extensive discussion about it, and we can do it at the time of the trial, but hearsay is evidence offered to prove the truth of the matter asserted, and there is also an exception for plan or present intent. I don't want to get too deeply into this, but you denounced it as irrelevant hearsay. The relevance is open to question, but I don't think it's hearsay because it's not being proved. At least I would not permit it to be used to prove that the entire police presence on that evening.
This judge is throwing out these hand signals all over the place. Oh my goodness! Someone should investigate him for supporting the president, Joe Biden. We need to fact check the white power claims of Bruce Schroeder with his every time he does this. We need to get a Reuters fact check on that stat pronto. Get it out there. Mfer and Emmer says thus far the judge seems to be doing a good job of not allowing the prosecution to control the narrative that can be presented to the jury. Very different than the rulings in the Chauvin trial that limited the defense. Yes, that's actually really important. The defense in Chauvin's trial, Eric Nelson did a really good job. There's some criticisms and some very fair criticisms, but Peter, what's his name? Whatever the judge's name, he was ruling against the defense constantly and in favor of the prosecution. Or even when he ruled in favor of the defense, it would still seem to work out for the prosecution very, very well. The defense in Chauvin's case was having a really rough go of it. Like when the prosecution improperly introduced evidence and the defense objected, and the judge is like, yeah, don't do it again. It's like, but we're worried about this time that they just did it right after you said they couldn't do it. And they literally just did it. Like, anything? Nothing. It's interesting to see the differences so far.
Evening.
But we are only at pretrial.
Appreciated Mr. Rittenhouse's behavior or his presence or whatever. So I don't think it's hearsay, and I don't want to get bogged down on that. Relevance is another matter, but he's addressed that. Do you want to respond to that?
I do. This would be akin to a police officer telling Mr. Rittenhouse at 1 p.m. that he stopped at a stop sign properly, and that's used as evidence to show that at 10 p.m. When he shoots and kills people, that somehow he's not reckless.
Nope.
They're remote in time. They're remote in behavior. They have no bearing on one another whatsoever.
It's a little different to say he stopped at a stop sign and then shot someone versus he was there with the gun in his hands defending property, and the police said, "We're glad you're here." Those are wildly different, not analogous at all. But we know what Binger likes about the word analogous, and that is anal.
The evidence with regard to these statements by anonymous law enforcement officers occurred earlier in the evening at a separate location with regard to separate behavior. And no one is going to argue in this case that the defendant was reckless or unjustified in desiring to protect private property, remaining at a private business location, and trying to secure that location. That is something.
You're not going to argue that? You're legitimately saying, Binger is saying right now that he is not going to argue. It's literally the crux of his argument. He's going to argue, or no one is going to argue, that Kyle being at that business, defending it with a gun that was allegedly illegal, according to Binger, no one is going to argue that was improper behavior. Wait, what? Are you serious? That's his whole argument. He came from a different state. He was carrying an illegal gun, acting like a vigilante in a community that didn't belong to him. That's the whole purpose of Binger's argument. He's now saying he's not going to argue that. I hope they recorded that so they could play it back every time he brings it up.
That countless people in Kenosha did that night and many nights around that time period, whether it was their own home or their business or their neighborhood, and they are well within their rights to do so. The activities that we're talking about in this trial did not occur at that location. They did not occur on private property. They did not occur in the course of protecting that.
Kyle shot Joseph Rosenbaum on private property. That was on private property. There's no doubt that Kyle Rittenhouse shot Joseph Rosenbaum, the first deceased, on private property. Hell, he was in a parking lot between cars. That's where the shooting occurred. That was on private property. The next two shootings occur on a public roadway only because Kyle Rittenhouse is retreating towards law enforcement at that point in time. But the first shooting absolutely occurred on private property. Maybe not the same private property where the police officer encountered Kyle Rittenhouse, but he's engaged in the same type of behavior.
Business. They occurred blocks away, far away from the location that Mr. Rittenhouse took it upon himself to guard that night, when he's out wandering on his own without any members of his group nearby, and he is getting himself involved in things that are well beyond his purview. These shootings that we're going to talk about this trial occurred well beyond the police lines, outside of the view of the police.
What was the law in Kenosha south of 60th Street on that night? Because when you were here last time, you were talking about the police zone, that the police had pushed people back, presumably to protect the public buildings in this area. But what was the status of law enforcement south of that? I mean, or down 60th Street, where there was enormous amount of looting and arson. What was the state of law in those areas?
There wasn't much. Absolutely. I agree, Your Honor. The police had made a decision that night that their resources would not allow them to get into this area and try and arrest every criminal, stop every crime,
Not
take
every,
care of
I'm talking about arson.
Your Honor, to be honest, the arson that night, the primary arson in this time period occurred on the nights before. On this particular night, there's very little arson. There's a dumpster, there is a trailer that's dragged out in the road. Over on 60th.
This is so disingenuous. This is so disingenuous because the mob has been burning Kenosha to the ground. The fact that it didn't occur at the same rate this night, well, there's a little arson. By the way, Kyle Rittenhouse is involved in putting out that little bit of arson that he's talking about. It's mostly peaceful arson. Kyle Rittenhouse is directly involved in the arson that did occur in trying to prevent it this night. He's got the fire extinguisher. They're pushing the dumpster where he is. Like, he's such a disingenuous prick to suggest that, well, it was arson a different night, but only a little arson tonight. It's only a little arson, but it's right where he is.
Yes, I think what you're referring to is over about 15th or 16th and 60th, right before the embankment. There's a car dealership, and I think the owners of the car dealership actually piled a bunch of tires in the middle of their parking lot and set them on fire for some reason. Didn't damage any cars.
That's
or
not
anything
arson.
like that. The arson.
That's not arson. You can pile a bunch of tires and burn them. I mean, that might be against some environmental regulation. That's not arson, you liar. Arson is intentionally setting a fire for the purpose of destroying property that you don't have a right to destroy. That's arson. Like, I can, if I'm not trying to defraud my insurance, I can burn my house down. I have a right to do so. It's mine. I can burn it down. I can burn down any building that I own. I can burn down whatever fuck I want on my own property that's mine, so long as I'm not doing it for the purposes of fraud, and so long as I'm controlling the fire in such a way that it doesn't endanger others. If the people set up a barrier of tires, that's not arson. We're not talking about arson. We're talking about the looters who were lighting a dumpster on fire and pushing it towards a gas station, you lying piece of shit. God, I fucking hate prosecutors. Oh, I hate them. Speaking of which, I have an email to send to a prosecutor tonight. Thank you. Thank you for reminding me, chat. You've brought me back to peace. I have an email to send to a prosecutor for a case that was just adjudicated. Mfer and Emra says something the same day is remote in time, but something several months prior is totally not remote. Got it. This is silly and time wasting from the ADA. Feels a lot of this is to make the defense burn funds. It's actually, no, I will disagree. I don't think prosecutors are particularly knowledgeable about defense attorneys and how much it costs to levy a competent defense. I legitimately don't, because the career path is typically not defense attorney to prosecutor. The career path is typically law school to prosecutor to governor to judge to something like that, or to defense attorney after you're a prosecutor. Usually you don't go private defense and then go into prosecution. Most prosecutors are not actually people who have billed a client in any particular way. They actually don't know the work that goes into private defense from their personal experience. Typically speaking, they tend to not go that career path, because once you're in, look, private defense attorneys who exclusively do serious criminal defense or even DUI defense or whatever, they're making 2 to 4 times what a prosecutor is going to make to start. Like, they're making a significant amount of money. Might take them a bit to get there, but they're billing at a much higher rate than a prosecutor. Prosecutors have job stability and government benefits. They don't have to worry about billing. It's, you flip a coin, you like one side, you like the other. But I don't think that I would wager Binger actually has probably no idea what billing is like.
That affected CarSource, for example.
But I'm also an asshole who thinks that Binger is a complete fucking moron. So there's that. Heel versus Babyface says mostly peaceful arson.
But,
hey, what's up, buddy?
A lot across the street occurred on one of the prior nights. The Department of Probation and Parole building occurred on one of the prior nights. So on this particular night, arson of large property is really not going on. There's a couple of minor, like I said, a dumpster fire and a trailer and things like that.
The dumpster that they attempted to push into a gas station, which would have caused a significantly different situation.
And by and large,
Who knows how that evening is going to develop?
Thank you.
these events occurred at about 11:45, 11:49 at night. So this is several hours into the evening. The crowd at this point
Well, you know what? Kyle should have omniscient knowledge of everything going on that night. I mean, he should know that there's only a little arson. I mean, he should know what's going on down, 4 blocks this way, 5 blocks this way, despite the fact that we've argued that him leaving the property at all makes him culpable for the crime. I mean, Your Honor, he should automatically know how much arson is occurring in the town that night based on what's going on contemporaneously, not what had happened the prior night.
There's clearly some property damage going on, particularly at the 63rd Street Car Source location.
Just a little.
There are individuals that are using clubs and metal bars to smash out car windows. Doesn't appear to be any arson going on, but there's certainly some property damage going on down there.
A little bit of
and to your
property
point,
damage.
Your Honor, the larger question you're asking is, was this a situation in which the law enforcement were going to come in there?
Oh, hey, I see Dizzy in the chat. Hey, Dizzy, you're a dumb motherfucker. There you go. I responded to you. Have fun. Fuck you.
And arrest people for smashing car windows or things like that? And no, I don't believe that's the case. So that is true. But again, the evidence that's being sought to be introduced here, Your Honor, is from a different time, a different location with regard to different behavior. And the only possible relevance this could have is to try and convince the jury that those statements gave the defendant the state of mind that he was then justified to wander off that location.
Yes, literally yes. You're making the defense's argument. Yeah, the officer's statements gave him the state of mind. Thank you. Brilliant.
Intervene in other behavior, confront unarmed individuals, and shoot and kill them.
Yes.
And again, like I said in my example, that would be like the police telling somebody several hours earlier that you stopped properly at a stop sign. It has no bearing. It has no relevance to what's going on. The argument that they want to make, and I understand the court's ruling on hearsay, but this is sort of backdoor hearsay, Your Honor. What's really going on here is it's under the color.
No, Binger. It's not any hearsay. The judge has already laid out why it's not hearsay. It's not backdoor. What the fuck? Backdoor hearsay doesn't exist. By the way, let me clarify this for you as an attorney. If there is a legally viable reason for anything, it doesn't matter what the non-legal reasons might be. And you know who established this for us? This wonderful rule? Cops pulling over black people for being black. That the cops made this rule. The state did it. Cops were doing this. They were pulling over black people who were speeding 1 mile over the limit because they were black. And then they would tell the court, well, why'd you pull him over? It's like, well, he was 1 mile over the limit. I wouldn't normally pull over someone who's 1 mile over the limit, but he was black. And the court would go, well, he was justified because he was 1 mile over the limit. And if you have a legal justification, your racist reasons for doing it do not matter. That's Supreme Court case law, baby. That's where that comes from. So if you have a statement that's not hearsay because you have a valid exception to hearsay, it doesn't matter that it might actually be hearsay in a different context because you have a legal exception to the hearsay preclusion. You already have the exception. It doesn't matter. The statement can't be backdoor hearsay. It can't be fisting hearsay. It can't be oral hearsay. Oral hearsay. It can't be just a rub above the clothes hearsay. It doesn't exist. That's not real. That's not a thing. It either is hearsay and is excluded, or you have a valid exception to the hearsay exclusion, like it speaks to the client's state of mind, or it's not being offered to prove the truth of the matter, or it's an excited utterance, or literally any number of valid exceptions to the hearsay exclusion. There is No thing where you get to go, well, it's an exclusion, but Your Honor, it's also hearsay, so we need it removed. Nope, you've got an exclusion. You already lose. If I was this judge, I'd be so annoyed that this guy was keeping up this fight. Look, I told you it's not hearsay. Listen, I told you. I just told you. I'm the judge, and I just told you it's not hearsay. Why do you keep telling me it's hearsay? I just told you it's not. You're supposed to argue relevance. You told me you were going to argue relevance, but you're not arguing relevance. You're arguing hearsay. I told you it's not hearsay.
We want this jury to believe that the law enforcement officers approved of what was going on that night. We're not going to introduce it purportedly for the truth of the matter asserted, but it's going to come in and the jury is going to be under the guise that this is being approved by law enforcement. And that's not at all the case here.
Sucks
There's
to be
no
you.
evidence that any law enforcement agency approved of what the defendant was doing when he left 59th Street car source.
That's actually, here's the thing. If you enter evidence that one law enforcement officer approved of something, guess what? That approval and knowledge is imputed on the entire police department, because thanks police for doing that one too. When one member of law enforcement agency knows something, that knowledge is imputed on the rest of the law enforcement agency, whether it's reasonable or not to impute that knowledge. So if the law enforcement officers who saw Kyle and said, hey, good time. We're happy to have you. If they did that, then the knowledge of Kyle Rittenhouse's activities are actually, for the purposes of the Fourth Amendment, for example, would be imputed upon the rest of the department. All of them would be knowledgeable of Kyle Rittenhouse's activity by nature that one of them was knowledgeable of Kyle Rittenhouse's activity. So you don't get to make that argument either.
When he started wandering the streets with a gun, when he's out after curfew on public property, when he's carrying a gun illegally, when he's getting involved with unarmed individuals, intervening in their property, and then eventually shooting and killing them. There's no law enforcement approval of that. There's no law enforcement involvement in that whatsoever. It is completely separated in time, in location, and in the quality of the incident and the type of behavior involved. So for those reasons, Your Honor, this has no relevance to the issues at the court. And I think it does run.
He has not argued a single issue of relevance. He's only argued hearsay. He's made the main thing. This judge, I'm guessing, is going to go, you just care about the hearsays. Stop it.
The risk of undue prejudice here and confusion of the issues, because the jury could conclude that, well, if the police saw him and they thought he was doing everything okay, then this shooting is justified. And as the court has acknowledged, that is not the issue here. That is not something the jury can conclude in this case. They have to make their decision based on the facts and the law, not on whether the police may or may not have given their stamp of approval.
Again, it's the state of mind of the defendant. That is the law. That's the law that you charged him under.
On any sort of behavior here. So I think it runs the risk of undue prejudice, of confusion, and frankly, I think it takes some of the ultimate decisions out of the jury's hands. The jury is the one who needs to make this decision. And giving the color of some sort of law enforcement approval here, I think interferes in that process impermissibly.
Well, I agree with your concern about the suggestion of some sort of an imprimatur from the police as to the defendant's behavior. Of course, the defendant's behavior at the time that the police allegedly saw him was different from his behavior at the time of the incidents. But I think the defense makes a very good point that I'm going to be telling the jury about things they are to consider on the reckless conduct charges, and they're specifically told, consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether well, it goes on. But the point is, if the jury is being told, I think the defense point is that if the police, if the defendant is walking down the sidewalk or the street and doing what he claims he was hired to do, And the police tell him it's a good thing you people are here in the given the state of lawlessness that's existing. Is that something that's influencing the defendant and emboldening him in his behavior? That's
a relevant jury question. Bruce Schroeder, bravo for not being an absolute government pile of trash. Like, again, so far, like, this guy, I'm sad that he didn't dismiss the illegal firearm charge out of hand. But I mean, this guy is consistently correct in his legal analysis. He's consistently correct in his assessment of what's going on between the parties. He is right on here. Let's see. Okay, here we go. Sorry about that. I had to make sure there wasn't an emergency going on. But man, he has been great. And here's the thing. Here's what you want. This is literally what you want. A judge that follows the rules. That's all you could ask for in this world. A judge who consistently applies the rules, because then you know exactly what to expect. It's written down. I agree. It's written. Dizzy, you dumb motherfucker. He says defending yourself when you're doing something illegal is not the law. Yes, it is, you stupid monster. Oh, God, you're a law enforcement officer? Retire. Retire to Bermuda. Retire to somewhere else with all of the fucking money you stole through civil asset forfeiture, you piece of shit. Get the hell out of here. Self-defense does not depend on legality or illegality of what you're doing. The relevant questions are, did you instigate the violence against you? And do you reasonably fear for imminent death or bodily harm? You dumb motherfucker. If you don't know that and you're a cop, you should quit. You should fucking quit or learn to read, you Neanderthal piece of shit. Fuck you. Get out. Back the blue except for you. Fuck you. I'm so tired of these dumb fucking cops coming in here misstating the law. No, you're the reason that shit goes down. You don't know the basics of the law. And you're out here trying to argue, oh, I'm an LEO. I know. You don't know shit, buddy. You know how to arrest people and find a fucking criminal. That's all your job is. Your job is actually not to know the finer points of the law. I'm tired of cops saying they do know the finer points of the law. Often they're wrong. Routinely they're wrong. Every single time someone is off, is acquitted, every time someone is not guilty, the cops were wrong. That is something to remember. The cops were wrong. Every single not guilty verdict in this fucking country is a cop being wrong on the finer points of the law. Never, ever, ever listen to a cop say, I know the law. I'm a police officer. You actually don't. It's not your job to know the law. It never was your job to know the law. Your job is to find someone who might be guilty of a crime and let someone who knows the law figure it out. That's the difference. You're in here talking about, if you're doing something illegal. Oh, yeah, if you're jaywalking, you can't self-defense. Shut the fuck up, you dumb motherfucker. You stupid piece of shit. I'm so fucking tired of this. I'm so goddamn tired of pretend cop. You're probably not even a cop. The sad thing is, most cops actually do have some grasp of the law, and you fucking don't. That's the dumbest thing I've ever heard. No, if you're doing something illegal, well, if you're speeding, you have no right to self-defense if someone's trying to kill you in your car. Shut up. Shut your fucking mouth. You only don't have a right to self-defense if you instigate the instant violence and don't retreat in Wisconsin. Here's the bad part, buddy, for you. Kyle did retreat, even though he was under no obligation to do so, because the state has not proven beyond any reasonable doubt that he instigated the violence in the first place. Fuck you. You're stupid. Next. C Goody 564 says, Your Honor, that's balls deep hearsay. Jason Smoot says, oh, for fuck's sake, take a shot with us, Ricketa. I did. Now I'm going to take another one. If you break into someone's house and they threaten to kill you, can you argue self-defense? Not as easily. You would have to retreat. But here's the thing. If you break into someone's house and someone threatens to kill you and you retreat, and then they chase you into the street, they chase you down the road, you've indicated that you've quit the confrontation, they're chasing you with a gun, and then you shoot them, yeah, you can argue self-defense. In fact, in Minnesota, a guy was convicted of murder because he shot 2 people who broke into his house. Why? Because the confrontations were over, and he proceeded to go on and to taunt them and to shoot them after the fact, even though they were incapacitated by his prior shots. He executed them, and then he laughed about it. This idea that you lose your rights entirely to self-defense because you are committing some other unlawful act, that wasn't relevant, that did not instigate violence against you. Let's say that Kyle Rittenhouse gets convicted for the illegal gun charge, which he absolutely should not, but let's say he does. That does not negate his self-defense claim under Wisconsin law, not by any stretch of the imagination. Anyone who tells you otherwise is an idiot. Not only are they an idiot, they're the biggest idiot you can find. Because the person attacking Kyle Rittenhouse, unless he knows Kyle's age and knows the gun, like what does Kyle illegally carrying a gun do to instigate an attack? Because if Kyle were 18, like, again, we're going with the premise that Kyle illegally carried the gun for the sake of argument. Arguendo, Kyle was illegally carrying. Were Kyle 18 years old, he would be legally carrying the gun. So let's say his birthday was tomorrow, hypothetically. In this hypothetical situation, someone who's 17 years, 364 days is illegally carrying a gun. The next day, he turns 18 and is legally carrying a gun. How does the person assailing the person committing the illegal act, how is that person in any way, in any knowledge that the gun is carried illegally at that point? How is that related to the instigation of the attack? He's illegally carrying a gun. How do you know? In fact, many adults could be illegally carrying a gun. You'd have no idea. They might be a felon, for example. Like if Joseph Rosenbaum had a gun because he's a pedophile who raped a bunch of children because he's a fucking pedophile that Dizzy seems to love. Doesn't matter. Joseph Rosenbaum is a child rapist. If he were carrying a gun, how would anybody know that he was a child rapist, right? Unless you had personal knowledge of the child rape. You just be like, oh, there's an adult with a gun in Wisconsin. There's lots of adults with guns in Wisconsin. You wouldn't know that he fucked little boys in the ass because he's a disgusting piece of shit that deserved more bullets than went into him. He also deserved to be lit on fire. He deserved the nuclear bomb to be dropped on him. He deserved to have to eat at Hardee's for the rest of his life. He's a piece of garbage who raped children. We're out here pretending that this is some loss to society. Fuck Joseph Rosenbaum harder than he fucked kids. And fuck Dizzy for supporting people like him. All right. Back to this.
The issue I think that they're suggesting, which would seem to me to be an argument for relevance.
Your Honor, I think it's important to clarify that this was not a situation in which the defendant was walking down the street when he encountered the police. You have clarified something that I think is important to keep in mind, which is that the police had established a line at 60th and Sheridan and had moved all of the individuals from the streets south of that line. When the interactions that we're talking about between the defendant and law enforcement occurred, it was while the police were passing by the 59th Street car source down to 60th to establish this line.
So
once they pass the 59th Street car source, there are no viable threats to that location anymore. All of the individuals from the street.
You see the judge's face?
Have been moved out of that location. At that point, the 59th Street car source is essentially behind police lines. It is in a zone of relative safety at that point.
Now, for some reason, I formed the impression perhaps incorrect. And of course, I don't have nearly the wealth of information that you people have, but I formed the impression that the car source north of 60th Street had a common ownership with the one at 63rd Street?
That's correct. There are 3 car source lots. One is on the east side and in the 5800 block of Sheridan. One is on the west side in the 5900 block. And then there's the one down at 63rd where the eventual first shooting occurs. The defendant and his group of compadres are at the 59th Street location. They spend almost the entire evening at that location. They have taken it upon themselves to guard that physical location. And as I said, when these...
I'd like to, are we going to find out? And
by the way, this prosecutor, what he's doing right now is really interesting. This prosecutor is establishing fact prior to laying any foundation for how he knows any of this factual material. This stuff, there's no proper foundation for the prosecutor to have knowledge about what these guys were doing. No one has testified in this case at this point. There are no affidavits that say this. We don't have depositions of these people to establish this, where the defense would have the proper ability to cross-examine. No one has actually established any of this stuff. He's just saying it. He's saying it based on accusation. He's about to probably be reminded of the fact that none of this has actually been established yet, as a matter of fact.
I don't want to be injecting things. You say they have taken it upon themselves. Was this something that was done out of the charity of their hearts, or were they being employed to do this?
They were not being employed. They were not paid. They were not hired. They're not licensed security guards.
Judge, we have photographs of all of those gentlemen with the owner of the car source taking photos that night together.
You have fact questions for jury trial here, Binger. You can't do this.
2 of the people had worked at car source previously. They had been given entrance into the building and ladders to go up on the roof that evening. So the idea that they had commandeered this building, that is not what the evidence in this case is gonna bear out at all.
Notice that was subtle by Sarifsi. He's really good. I wish I remembered his name better. It's not his fault. I'm bad at names, and his name isn't on screen right now, and he's not Richards. What the evidence in this case will bear out. It's very subtle. They haven't established anything. We haven't gone to trial yet. There is no fact finder yet. They haven't even paneled a jury. These are all matters of law that Bruce Schroeder is to determine. Binger is arguing a lot of fact questions.
And that's not what I said. What I said is they were not hired to do this. Now, there were communications with the owner of this particular location where there was some sort of understanding as to what their responsibilities were going to be. But my point is, Your Honor, the larger point here is that when the police statements that we're talking about that you've ruled are not hearsay occur, they occur as the police Bearcats are moving past 59th Street car source and establishing that line at 60th. So they're, at that point, the 59th Street location is essentially behind police lines. It is now no longer in any sort of danger at this point. What happens after that, after some time, is the defendant then leaves that location on foot and winds up south of 60th on his own. That's when the shootings occur. So that's when I said earlier.
Well, he left the property. That means he gets to be killed. Oh, okay. Thanks.
There's a distinction in terms of the amount of time and the location and the behavior. That's what I'm talking about. He crosses the police lines south of 60th. He goes out into crowds by himself with no backup, and eventually winds up 4 blocks south at 63rd Street, where he engages with Mr. Rosenbaum.
Well, regardless of where he was and what the state of law enforcement of any kind it was at that time, I'm not sure are really critical questions. the question is whether the defendant, whether the statements or statement that the defense is interested in presenting is something that would bear on the mind of the defendant, which is what we're looking for on all these charges, what the state of mind of the accused was. And I will tell the jury, as we always do, you can't look into a person's mind to find out his intent, but you're to consider what he was doing, why he was doing it, among other things. And I don't know. It seems to me my bias at this point would be towards allowing that evidence in, but I'm like so many other things. As you know, you've tried cases in here. I'm the one who always wants to hold back until I see the whole field of evidence, because I just hate being up here after making a ruling and saying something will or won't come in, and everyone's planning on that, and then suddenly say, whoops, I just changed my mind. So I don't want to do that. So I give you, in many instances, what I'm thinking about as far as part of what's going to be the ruling. And I would tell you at this point, I would think that probably is admissible in this case.
Understood. Thank you.
Okay, so then let's see. We might as well start as long as we're on that motion with the reference to you're asking that the defense be prohibited from referring to Joseph Rosenbaum, Anthony Huber, or Gage Grosskreutz as rioters, looters, or arsonists.
This is a really interesting question. So again, I don't know how the judge rules on this. I have no idea, but I think he's likely to rule in favor of the prosecution on this. The prosecution is not allowed to call Rosenbaum, Gage, and Huber. They're not allowed to call them. The defense is not allowed to call them, or the prosecutor's not allowed to call them victims. I think the judge will likely say that the defense cannot call them rioters or looters or something akin to that. I think they might win on this issue.
Or any other pejorative terms. And then the defense has filed a response alleging some behavior. Let's start with Mr. Rosenbaum prior to the incident. Go ahead.
Which party would you like to hear from first, Your Honor?
I don't know, let's see. You're asking me to make a prior determination about what they can and can't say in argument, and we're getting way ahead now. I certainly wouldn't let them. Well, I don't want to say that. Am I doing something wrong?
Am I doing something wrong? Who are you asking? What happened?
Can't do HDMI up there. At the same time, I'm zooming. Can you put the zoom from the TV up there?
He's got a tech issue.
That is the zoom. Screen share their exhibits.
You could just do the defense experts first, the use of force experts first.
Sure.
They're all sitting there, get that done, and then move on back to the motions and whatnot.
Is Dr. Black going to testify, or you mean the state's witness, use of force?
I don't believe Dr. Black is going to testify today.
Well, all right. Any reason we shouldn't just go to Dr. Black right now, or Mr. Willis right now, and we'll take this up later?
That's fine.
Okay. Mr. Willis, you ready for examination?
Yes, I am.
Okay. Would you be kind enough raise your right hand?
Shit. We're going to get into Bob's testimony now? I thought we were ruling on these motions and the other motion. Okay. Here's the deal. If we start on Bob's testimony now, I'm going to have to cut it off because I won't be able to do the whole thing. I won't be able to finish Bob's testimony tonight unless it's literally 5 minutes. It's because I got too heated and ranted about stuff and talked about other stuff. But I'm planning on ending the show in 36 minutes, and I've got super chats to read. So I think I think we should do, Bob is very short, says Jay. Bob is very short. Okay. Okay. Look, I trust Jay with no reason to do so other than I know Jay is smart because he subscribes to the show. All right. Let's show Bob. Bob is very short. John Black's testimony was really long. Okay. John Black's testimony was a long process. It was, over an hour. Jay said, if Jay is wrong, I'm going to come to Jay's house and I'm going to pee on his bushes. But let's do Bob here. This will be great. And then we'll see where we're at since it's short.
You solemnly swear that the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
Yes, sir, I do.
Go ahead, Mr. Binger.
Could you state your name for the record?
First name is Robert, R-O-B-E-R-T. Middle initial is C for Charles. Last name is Willis, W-I-L-L-I-S.
Are you currently employed?
Well, I am self-employed as a consultant. I am retired from previous employment and on a pension.
What was your prior employment?
I've had several. The most recent would be
Walmart, Target, JCPenney.
I was an instructor, teacher at Northeast Wisconsin Technical College in Green Bay, primarily in police sciences and the police academy.
Over what period of time did you hold that employment?
Oh, probably from about the year 2002-ish till late 2015. I had also worked there previous as an adjunct instructor. That's a part-time instructor.
When you were an instructor at the Northeast Wisconsin Technical College, what subjects did you instruct on?
A huge variety, actually. I was somewhat their utility man. I taught in the police academy, and my primary responsibility was use of force, defensive tactics, control tactics.
Wait, at the technical college, you were teaching police use of force? Why? What course at the technical college was police use of force?
Pepper spray, taser, baton, those sorts of things, firearms. And I also taught professional communication skills, crisis intervention, taught vehicle contacts, vehicle stops, emergency vehicle operation, and then a host of academic subjects ranging from ethics to constitutional law to criminal law, juvenile law.
Why is this guy teaching constitutional law, criminal law, and juvenile? Is this guy an attorney? Does this guy have an education in law? Like, did he go to law school? What the fuck is he? What?
How to testify in court, and again, a host of other academic topics. I also taught in-service officers, that would be Brown County, Green Bay, and the surrounding counties, 7 different counties. Their officers would take their yearly in-service training, continued education. I would teach those programs. I then also taught instructor level classes for the state of Wisconsin, and I did that teaching at Northeast Wisconsin Technical College. So those topics I discussed before initially, defensive tactics and so forth, were the instructor level courses that I would teach at that school. I also taught civilian.
Like, look, if Bob is a former cop and he's going to teach police tactics or whatever, great, wonderful. Why is he teaching con law? Like, I'm sorry, again, you clearly heard my opinion on police who say they know the law. Con law is a very complicated subject that should never be taught by someone without a law degree of some sort, and preferably an LLM, a legal master's in constitutional law. Like that's who you want teaching this, or someone who either has a legal master's in constitutional law or maybe practiced constitutional law professionally for, several years. I teach constitutional law at the high school and junior high level in a homeschool co-op. I would not purport to be an adjunct professor of constitutional law at a law school, right? Like I don't practice constitutional law. I mean, could I do it? Sure. I'd have to do a bunch of research and prepare a course structure and all that. But like, there are better qualified people to teach con law than me at the postgraduate level, or even at the graduate level. Like what, who's taking con law in undergrad at a tech school? I don't understand. I'm just confused by this. Because look, con law is really easy to get wrong. It's really easy to get wrong by someone who has no idea what they're talking about. You don't. Okay.
Civilians, I taught concealed carry, and I taught security officers, civilian security officers. That just gives you a general sense, I think.
Now, you said that during your time at the Northeast Wisconsin Technical College, you were an instructor at the police academy. Is that right?
Correct. They're police academies. There's 20-some different academies in the state of Wisconsin, but they all teach the same curriculum.
Is it fair to say then that the students that you taught at the police academy were students who were learning how to become police officers?
Correct.
Oh.
During the time period that you were working at the Northeast Wisconsin Technical College, did you also do consulting work?
I did, yes.
What sort of consulting work did you do?
Well, I did work much similar to what I'm doing here. That would be consulting in civil, criminal cases, disciplinary hearings, administrative hearings, and offering my testimony when it was wished. That would include authoring reports, testifying in court, being involved in depositions, and so forth. I also taught for some private companies. When I had any free time, I would teach for a company called Caliber Press, doing a street.
Let's just point out that the difference in CVs between John Black and Bob is embarrassing so far. John Black is a guy who has trained people for 30 years on use of force, and is also a literal expert on analyzing video. He has a PhD in analyzing video, who has also taught use of force for 30 years. Bob taught police tactics at an undergrad. Okay.
Survival seminar. I only did that a couple of years, and I guess that's over it.
Can you repeat that, please? About street survival?
Oh, okay. Part of my consulting was to teach a course of instruction around the country for a private company called Caliber Press. It was the street survival seminar.
What were the types of subjects that were covered by the street survival seminar?
Pretty much the same topics, except it expanded a bit to how stress affects decisions, especially.
Literally nothing in his CV so far talks about why he is an expert on the use of force in self-defense situations and its legality. Like again, the other guy, his entire thing was teaching proper self-defense use of force. Like he's a certified instructor to both civilian and military, like to law enforcement, to everybody. And he's taught for 30 years, he has taught the legal and practical sides of self-defense situations. What has Bob said so far?
Those in use of force, how physiological, psychological, emotional decisions are affected by stress. There was a bit of that, not much.
A bit.
And I did infuse my teaching at Northeast Wisconsin Technical College with those topics as well.
A bit and infused.
During the time period that you were teaching at the Northeast Wisconsin Technical College, did you also serve in law enforcement?
Right, that's like a janitor, right? Like I'm not actually trying to shit on Bob. He sounds like an expert in a lot of topics, but not this one. And remember, the prosecution criticized John Black, who literally is an expert in these topics. They criticized him because he taught law enforcement and military in addition to civilians. Bob has not indicated anywhere where he teaches civilians about civilian use of force. He's only indicated that he's taught law enforcement over and over. It's inconsistent with the prosecution's argument. Bob seems like a fine gentleman who teaches competently on the subjects in which he has knowledge. But it's kind of like a janitor walking in and mopping up Jeff Bezos' office and says, well, I infused a little bit of how to be a CEO into my experience as a maintenance technician. Like, what are you talking about, buddy? Yeah, where on earth, what is your relevant qualification to talk about the civilian use of force in a self-defense situation?
Yes, I did. I was a deputy sheriff, sworn deputy sheriff for Brown County. Although, since I was already getting a salary from Northeast Wisconsin Technical College, I didn't think it ethical to double dip. So I was not taking a salary, and my work was mostly as a consultant and trainer for the sheriff's department in Brown County, doing things like doing updates in taser recertifications.
Literally the criticism the prosecution raised against Black.
Helping with some policy decisions and basically serving at the pleasure of the sheriff. I was not out making arrests nor on patrol.
How long did you serve with the Brown County Sheriff's Department?
I believe records with the state would indicate that till about 2013 or so.
From when?
Other than that time that you were with the Brown County Sheriff's Department, do you have any other active?
Remember, John Black said, I could figure out a way to murder someone with a skateboard. Like, why are we even listening to Bob when that is on John's CV?
Do you have law enforcement experience?
Yes. For approximately 10 years, I was a police officer with the city of New Berlin, Wisconsin, which is in the metro area of Milwaukee. It's a suburb of Milwaukee. It's actually in the adjoining county, which is Waukesha County, but it's right on the border. I also did part-time. I did that for 10 years from about 1983 till 92-ish or so. I also did part-time lake patrol work for the town of Merton. And again, continued that into the 2012, 2013 era. But that was very part-time. It was primarily in the summers, and it was patrol on the lakes.
Other than the time that you were an adjunct faculty member and an instructor at the Northeast Wisconsin Technical College, have you spent any other time as a teacher or an instructor?
Oh, yes. I started my teaching even before I was a police officer. I ran a martial arts school. Apparently, word got out that I was reputable and realistic. I gathered a clientele of police officers and came to the attention of Milwaukee Area Technical College and the state of Wisconsin. I then taught not how to be a police officer, because of course I wasn't one at that time, but on how to deal with violent people. And I was asked to become part of back then it was called the RISC program, It's now the DAT, or Defensive and Arrest Tactics program, and to teach that course of instruction at Milwaukee Area Technical College, at Waukesha Area Technical College, and then instructor courses throughout the state, primarily at all the technical colleges, at the Milwaukee Police Department, the Milwaukee Sheriff's Department, the State Patrol Academy, and anywhere that there are people wishing to become instructors in.
Wouldn't you ask your expert witness, how many men have you killed? Right? Like, that's the question. Like, John Black, look at that guy. Look at him. He's like military for X amount of years, cop for X amount of years. He's trained all these people. He's talked about how he could turn a skateboard into a murder factory. John Black, how many people in your life have you brutally and destructively murdered? And then you ask Bob the same question. I want to know the answer. That's how I'm picking my expert. How many bodies do you have under your belt?
Defensive and Arrest Tactics and those other courses that I've mentioned.
Did you also spend some time working with the Waukesha County Technical College?
Yes, I did. I did so from about 1984. In fact, ironically, I taught my own defensive tactics class when I was a recruit there in 1984.
That's not ironic.
Because I had that previous experience and had the, I guess, the okay of MATC that I was doing an okay job.
That's literally not, that is nothing. There's not a shred of irony in that. Oh my God.
I continued there for, I'd have to check my records, but several years. The entire time I worked for the city of New Berlin, I continued to teach at Waukesha Tech. So well into 1990, 91, something, 92 possibly, I taught part-time while I was a full-time officer at Waukesha Tech and their police academy.
Now, in terms of the instructing and the teaching that you've done in the past, has any of that involved issues of the use of deadly force or self-defense?
Yes, much of it has, yes.
For civilians?
Can you be more specific about how your instructing and teaching has focused on those areas?
Well, after having begun teaching defensive and arrest tactics, in 1986, I was asked by a man named Dennis Hansen of Training and Standards, he was the director of Training and Standards, to do two things. One, to write the Defensive and Arrest Tactics Manual, which included all discussion on use of force and deadly force. One might think a discussion about deadly force might find its way in the
Defense and Arrest Tactics. Again, all of this sounds like law enforcement.
Firearms Manual, but I was told to put it in the Defensive and Arrest Tactics Manual, and that would be the sole source for theory on use of force and use of deadly force. So I did author that document, and the second thing I was asked to do was begin teaching instructor courses that would teach that manual so that it would be the manual taught in all academies. By the late 80s, early 90s, that was accomplished. I continued, again, generally, I always taught defensive and arrest tactics, always taught use of force, always taught the use of deadly force, and of course included that in other venues where it was appropriate, such as if you are going to teach professional communications, that certainly is a very low level of involvement, but it is still, in many views, a use of force. So you would talk about use of force even when speaking about something like professional communication skills. Or certainly if you're teaching pepper spray, oleoresin capsicum, or teaching
capsicum. Yeah. Oh yeah. You know, when you're teaching communication skills. Oh, well, I mean, I'm teaching communications, but occasionally we sprinkle in some deadly force to figure it out. What the fuck are you talking about? This guy's supposed to be the prosecution's expert, and he can't articulate where he teaches specifically about the use of deadly force by a civilian.
Taser or any of those things, again, the discussions of use of force and use of deadly force would enter in. Certainly in teaching firearms, that would enter in as well.
Certainly it would.
What is your educational background?
I went to Mfer High School in Milwaukee, Wisconsin. Graduated from there, I believe, in 1967. From 67 to 71, I attended Marquette University and graduated from.
Move this along, excuse me. Can we just move the CV into evidence? Otherwise, we're going to be here till 9 o'clock tonight. It's 67 pages.
Mark Richards has no chill.
I'll stipulate.
Bruce, you got to get on
Yes,
mic.
and the CV, and that he is qualified to testify for what the state's calling him. As to the report, we can deal with this at a later time. I'm not looking to delay this. There's certain things in the report that contain evidence that the court has ruled isn't coming in, so I don't want to waive my objection to that.
Is that acceptable?
I'm not sure I understand what's being proposed. If I'm understanding.
He's saying we stipulate to this guy's CV, just make him stop talking about what he's done. For Christ's sake, can we get to the important stuff?
Saying Mr. Richards correctly, there's not going to be a challenge to Mr. Willis's qualifications as an expert on the issue of use of deadly force in self-defense. Is that accurate?
This hearing, correct.
That's fine with me.
Go ahead.
Your Honor, for the record, I will then provide, and I believe these have already been marked and presented to the court. Exhibit 3 is the CV or curriculum vitae prepared by Mr. Willis. My understanding is there's no objection to that, so that'll be introduced for the purposes of this hearing. And then exhibit number 4 is the report that Mr. Willis prepared, and I'll move on to that now. Mr.
Arvid Arvidsson says this is how Bob got all of his qualifications. He just sat down for the interview and talked endlessly, and they just like, oh God, we agree. You're fine. Please shut up.
Mr. Willis, do you have your report in front of you?
Yes, sir, I do.
And for the record, that is a document which has a total of 44 pages. Is that correct?
Yes, it is.
We are 14 likes away from 1,500 likes. If you get me there, I have to drink another shot of 60% alcohol. And I don't know if I need it.
On the second page, there is a letter that you wrote me, which is dated October 18th, 2021. Do you see that?
Yes, I do.
Is that the date that you finalized your report in this case?
It was the date I was told to have it finalized, so yes, it was finalized by that date. Perhaps the
and so
then.
Be quiet, Bob.
So, Mr. Willis, I'll represent
yes
to you that Exhibit 4 is the report with that dated letter, which is 44 pages in length. And does that summarize your expert opinion in this case?
As best a report can, yes.
Your Honor, I'd move Exhibit 4 into evidence for the purposes of this hearing.
I have no objection, subject to my earlier objection. Specifically, he refers to some of the events the court has ruled not admissible regarding CVS.
All right. Go ahead.
Okay, so if you didn't check that, or if you didn't follow that, Mark Richards just objected to the inclusion, and I can't figure out why this would be included in Bob's report, especially when Bob produced this report after the last hearing. But he included the CVS incident, which was Kyle Rittenhouse in a car with his friend talking about shooting people who were stealing or purportedly stealing from a CVS. He said, wish I could shoot these people or whatever. the judge has already excluded evidence or testimony surrounding the events of the CVS, as they're completely irrelevant to Kyle's state of mind at the time that he's pulling the trigger against Joseph Rosenbaum. So for whatever reason, Bob decided to include in his analysis Kyle's statements at the CVS, even though Bob was told at the last hearing not to include statements about the CVS. He still did so.
Your Honor, maybe we can short circuit this a little bit. I understand Mr. Richards essentially conceding that Mr. Willis is qualified. The court will recall
Fractal Machine sent a chat that I should hit. It says, remember that Bob's report was super late. Bob's report was months late as well.
My motion was not specifically aimed at the qualifications of Dr. Black. It was more a overall question as to whether or not the jury needs expert testimony to begin with. And I don't have any serious objection to Dr. Black's qualifications in general. So I think we're both on the same page with regard to our experts. I think, like I said, I think the basis for my motion was that I don't think the jury needs this sort of testimony. So if the court is inclined to allow these experts to present their testimony to the jury, then I don't know that there's any further that we need to go today.
Well,
what's the defense want?
I want to understand the scope of your stipulation. Allowing this type of testimony is well, it's a Daubert hearing is what it is. And
Naked Frame says Dizzy is Rosenbaum's son. That's why he is butthurt. Oh, damn. Gross.
I did review both of the reports. There was a good deal of material that I'm not going to permit. I know that already without even having a hearing anymore. Based upon what I read. And I'm certainly not going, well, I don't want to say that. I almost certainly am not going to permit any opinion from anybody on the ultimate facts in the case. But I will hear you on what aspects you do want, if any, to be permitted from these people. So I guess the defense struck first with Dr. Black's report.
And they had quite a bit of time to cross-examine him, ask him questions, test his opinions.
Yeah.
I think I should get to ask Mr. Willis a few questions.
Well, I agree with that. I will say this. I guess I'm going to ask each of you.
Guys, do not even joke about Schroeder having COVID, because if that motherfucker gets COVID and dies and we get some stupid fucking Karen in this, I quit life. Not really, but I'm going to be so goddamn mad. No jokes. Look, all of your gay DBZ energy or whatever, you better be powering Bruce Schroeder's pacemaker's spirit bomb. That motherfucker lives through this trial or I get really pissed.
You'll be permitted to comment on the other's response. Here's the definition of when I can admit opinion evidence and this type of evidence. Is the testimony about scientific, technical, or other specialized knowledge? Will it assist the trier of fact to understand the evidence or to determine a fact and issue? Is the witness qualified as an expert by knowledge, skill, training, or education? Is the testimony based upon sufficient facts or data? Those are the big four, and then is the testimony of the product of reliable principles and methods, and has the witness applied the principles and methods reliably to the case, which I think is probably less important I'll leave it I'll leave that without further statement. And then there are some 5 additional criteria that the Federal Advisory Committee has recommended, but let's just talk about those ones I've already mentioned. Starting with the defense, who brought the first report up. How does Dr. Black's testimony meet it, and why doesn't Mr. Willis's?
Your Honor, if Dr. Black's testimony, as for what we're offering it for, meets it, Mr. Willis's would meet it under the same areas, okay? And what we're talking about specifically, much of with Dr. Black, is his analysis of the situation from a non-law enforcement individual, and his ability to analyze those videotapes frame by frame for the timing. When we've looked at this case, and I've discussed it with numerous people, when one looks at the still pictures, just still photographs, it seems to take forever for the events to unfold. When one looks at the videos, it seems to go snap of an eye. And we tried to break it down for time, so how fast these things are occurring.
Ah, the ever famous snap of an eye.
How fast Kyle Rittenhouse is having to make his decisions, and that goes into the mindset of whether it's reasonable for somebody of his age and stature in that situation. And the information that Dr. Black put forth regarding the first incident at Car Source 3, 63rd and Sheridan involving Mr. Rosenbaum is the fact that Kyle was being chased. He tried to avoid Mr. Rosenbaum. He continues on, turns around. Mr. Rosenbaum is lunging for him, and he's shot 4 times in less than 1 second. Those 4 shots, the 0 shot, and then the last shot was 76 or 77 hundredths, and that's based upon the frames. Then he gets up from there, sees Mr. Rosenbaum, the threats, the mob begins coalescing, saying things, and Kyle heads down Sheridan Road, I always get my directions wrong, in a northerly direction towards the police line, where he's approached by Mr. Grosskowitz, unarmed, and Kyle Rittenhouse does nothing to Mr. Grosskowitz other than have a brief conversation. Hey, did you just shoot that guy, Gage Grosskowitz asked. Kyle Rittenhouse replies, I'm going to turn myself into the police. I had to. And it's our position, obviously, that he had to shoot, putting forth his self-defense. He heads down the road, and he's attacked by the mob, which is event number 2, from the unidentified person who I've referred to as.
Holy shit, that's something I didn't catch. Kyle had a previous discussion with Gage Grosskowitz where after shooting Joseph Rosenbaum, he tells Gage Grosskowitz, I'm on my way to turn myself in. I had no idea that they had a prior conversation. That's amazing.
Jump kick man. The first and second shot at him, which are the only 2 shots that miss, to Mr. Grosskowitz is less than 7 seconds total. All those events happened. He's hit in the back of the head. This will be a point of major contention. He's hit in the back of the head with a skateboard and a rock. Mr. Binger says he just fell because he's clumsy, which the evidence will not bear that out. He's on the ground and he's attacked. There's an individual to, I believe, Kyle's left. There's numerous camera angles at this time, who comes at Kyle. Kyle points his gun his direction, does not fire. That individual backs up. No shot is fired. As that's happening, he's kicked in the face by the man we refer to as jump kick man. And at that point, Mr. Huber goes in for the second whack with the skateboard to Kyle's head and neck. Not his body, his head and his neck. Clearly depicted on the video, still photographs from 2 individuals, Tafin Coxon and Hispanic surname, and the name escapes me right now, but Hernandez, Drew Hernandez. Those photographs are there. As Huber comes in, hits him in the head with the skateboard, and grabs for Mr. Rittenhouse gun with his bare hand, pulling on the gun away. That's when the third shot is fired from Kyle Rittenhouse in event number 2. As soon as that happens, Huber falls away. Gage Groskowitz runs up to my client with his arm in his right hand, his firearm.
That's a funny Freudian slip, right? He runs up to him with his arm that would later be deleted. That's what's going through Richards' mind right now. He's like, oh, wait, I mean his gun. That's what I was talking about. I wasn't talking about his bicep that was going to be evaporated faster than a glacier in Tunisia.
In his right hand, his phone in his left hand. Both of his hands occupied, unable to grab anything. And Kyle points the firearm at him. This is all on video. As he points the firearm at Gage Groskowitz, he stops his advance, puts his hands up like the international I surrender. Something in Mr. Groskowitz's mind, I believe, he believes, Mr. Groskowitz, this will be a point of contention, he thinks Kyle's gun is jammed. As that happens, according to Black's testimony, he backs up, loads his foot, and then lunges towards Kyle, going in a direction closer to him with his right hand arm pointing directly at Kyle's head. Kyle fires one shot, hitting Mr. Groskowitz in the arm. That whole second event, from jump kick to Gage Groskowitz, according to the video footage and scoring it by frame, took 7 seconds.
That's amazing, by the way. That's an amazing thing to consider. Kyle is kicked in the face. Less than 7 seconds later, he has killed a man and evaporated the bicep of a soy boy. Like, that has happened that fast. It's really, really short.
All those decisions were made lightning fast by Kyle Rittenhouse. And what was observed by Mr. Black, seeing the individual back away, seeing Kyle point the firearm at Gage Groskowitz, he backs away, does not fire. After he shoots Mr. Groskowitz, an individual with a pipe or a big post and another individual close in on him, he points the firearm at both of them, they back up, showing firearm discipline. They get up, Kyle gets up, they don't get up, they're up. Kyle gets up, rises to his feet, once again begins heading to the police line at 60th and Sheridan Road. As he's heading in that direction, 3 more shots ring out from behind him. Kyle turns around, addresses where he perceives those shots are coming from, does not fire recklessly in that direction.
Kyle is not COD trained. If he was, he would have 360'd before every shot. Come on, embarrassing.
Turns around once there's the threat assessed and heads to the police, puts his hands up at that time, walks up to the police car where he tries to turn himself in, and the member of the Kenosha Police Department tells him to go home. And Mr. Black, one, analyzes the video frame by frame, has that, showing Mr. Huber trying to kneel on Kyle's chest to separate him from his firearm. He has the
if only Huber had kneeled on his neck.
Timing, and he assesses what he perceives as Kyle's perception regarding the individuals who are close to him but not firing, or he doesn't fire at. So it wasn't just anybody gets close to me, I fire. The fact that Gage Groskowitz runs up to him while being unarmed, he does not threaten him with a firearm because he perceives no threat to him. Those are the facts that Dr. Black can analyze and say to a jury, this is what I observed about the behavior of the defendant.
Holy shit. Jay says they argue for the next hour about Bob's report. Then the DA says they will not call Bob at trial. I can't sit. Jay, I thought Bob was short, but you meant Bob's testimony where Bob speaks was short. The resolution of the issue is going to take a while. We will do that tomorrow. I'm not going to sit here and belabor this point. Damn you, Jay. I was supposed to address Melinda Scott's video against me. I was supposed to address this very important thing, and you have stopped me from doing so. I will now fly to your house. I'm not going to fly to the airport near your house. I'm going to fly literally to your house. I'll parachute out as the plane crashes down. I'm going to piss on your bushes. I told the chat I would. What am I supposed to do? Jay, what am I supposed to do? You put me in this position. You did this, Jay. You brought this upon yourself. I hope you're self-flagellating. I hope you are self-flagellating. All right, let's wrap it up. Let's wrap up this show tonight. We've got some super chats to read. You guys have been amazing. We're at almost 1,850 likes. We're at 1,848. That's crazy town. Mandy Carvicka says, Nick, never trust anybody whose name begins with a J. That's true. That's true. You can't do it. You can't do it. Jay says you could walk to my house. Wait, really? you live around here? You live in the silliness of Spicer, Minnesota? No. If I'm in walking distance of you, you better email me. We can have a drink together or whatever. What are you talking about? That better not be true. Better not be true. Look, if you guys want me to drink, we're over 1,900 likes. I don't think we're going to get to 2,000, but I have a rule. The first 1,000 and then every 500 after. So if you get the next 100 likes, I will do it. It'll be a bad decision. We are going to do Twitch tonight. That is happening. We will resume here 1 hour, 5 minutes and 50 seconds on the video tomorrow. We will do that. We are going to cover this Kyle Rittenhouse case. I think it's one of the most important cases. You guys, God damn it, 2,000, how? Wait a minute. There's 1,679 people watching. We just got to 2,000 likes. That means some of you motherfuckers had not clicked like prior to me bitching about it. What the hell's wrong with you? Are you not entertained? Are you not entertained? What do I have to do? What do I have? You want me to get liver failure? You want me to be in stage 4 renal failure before you click like? What the fuck is wrong with you people? What kind of self-destructive, monstrous behavior and alcoholism do you even support? Oh, shit. Damn it. That's a lot of whiskey. This is 60% alcohol. I don't need this in my life. 2,100 likes. What the fuck? What were you people doing the whole show? The whole show. You were failing at this. I will never trust any of you again. Hey, Nick. Why don't you drink yourself to death on stream there, buddy? Good job, compadre. Hope you don't die, but I kind of wish you do. Jesus Christ. Any of you are sitting there just not clicking like... All right, here we go. We do have a couple justice chats. Atafos says, hey Nick, off topic. Oh shit, it's the same one you sent. Oh, you sent it on justice chat, and then you sent a super chat also. I'm gonna read them both. I'm gonna read them both. He says, hey Nick, off topic, but I was hit with a forklift at work. 7 weeks later, 2 bulge discs and 2 abyssal fractures later, still have the pain. Currently in physical therapy, but know of any work comp lawyers that I can talk to just in case I don't heal. Dude, it's not about not healing. Guys, let me be very clear on this. If you get injured at work, you are entitled to work comp and you are protected from retribution. You are entitled to that. That's your right. It's not an in case I don't heal thing. I mean, 7 weeks later, you're suffering injuries. You're entitled to work comp. And if they don't pay you, they have to pay huge fines along with it. Your attorney will probably resolve this with just a simple demand letter. But make sure, like, seriously, and they can't retaliate against you for this. It's not a bad thing. They're insured on this. It's okay. You should definitely talk to a work comp attorney. I did see your email, Adifos. I will respond to it when I am sober. Silky Johnson says, Nick is a professional grifter. Did you ask your client on the steps to grift even more? Yes. Yes, I did. But legally, also, no, I don't. I work for free. I do lawyer work for free. All of the legal representation I do has been supported by the show. Since I started this show, I stopped charging clients. Okay. Sorry. Minor correction. Not since I started the show, because I started the show in November of 2017. Since September of 2018, I stopped charging clients. I don't know who I would have charged between them, but I don't want to lie. I may not have, I may have, I don't remember what the caseload was, but definitely since September of 2018, when I decided to do YouTube full time, I stopped charging clients entirely. And because I said the show supports my ability to do this. And so the cases I do take, I will do pro bono. So there you go. Yeah. So no, there's no grifting. Also, let me guess, the judge was an angry, wall battered, eggless woman, and your client was younger, full of eggs in life, and more attractive. No, I think my client is probably comparable age to the judge. It wasn't about attractiveness or anything like that. It was just the judge had made up her mind. And guys, when a judge makes up their mind, you can appeal it if it's appealable. But other than that, you're pretty much stuck with the outcome. And it sucks. But them's the ropes. So I think that the judge made a decision that was fully within her purview. That's not the problem. It was the judge's the judge's berating of my client that was unnecessary. The moral grandstanding was unnecessary. None of that stuff needed to happen, and none of it was proper for an officer of the court to do. And I would humbly suggest that the prosecutor made an argument that wasn't an argument in any way. It was literally, the prosecutor did not make a single legal argument at all, but it's sentencing. You can make emotional arguments. And let's be real, my client's testimony was in many ways an emotional argument also. So everybody plays that game in sentencing, but it's very frustrating to see it from the state. Yeah, the prosecutor did not make a single legal argument. And again, I owe the prosecutor an email, which I'll be penning tonight, no matter how drunk I get. Because the prosecutor specifically lied about something. Let's do this. Let's do this right now. There was a large payment to the Minnesota Department of Education that was attributed to my client. And both the prosecutor and I believe the prosecutor indicated to the victims that my client paid for their child's college tuition as part of the embezzlement scheme. And this is a large payment. And so the victims stated in their impact statement that my client paid for their own child's tuition by stealing. My client didn't pay for their child's tuition because their child had a full ride scholarship. We have no idea where that charge came from. We have no idea what it's in relation to. But the prosecutor made the argument that my client did this and clearly told the victims that was my client's child's tuition. But it's sentencing. So, So I owe the prosecutor an email. By the way, maybe you should tell your fucking victims that you were wrong about this. Whoever told them that my client paid their child's tuition, my child had a full ride scholarship and their tuition was paid by the state of Minnesota. Or well, since it was to U of M, probably. But thank you for not checking on that and for just lying about it. It's fine. It's fine. You're just an officer of the court. You're just obligated to tell the truth to the court. You're just, you just have an obligation to maybe check on these things. Never did. Never asked. Mr. Snuffles, no, it doesn't matter. It doesn't matter. It's not a factor in anything. It just goes to the nature of prosecutors. Again, they had the opportunity to argue against what we asked for, and they made zero legal arguments. Zero. None. Or as Biden would say, zero. I love white people. That's none. Zero argument that was legal. It was entirely emotional. The judge is fine with it because, well, sentencing. Judge gets to pretend that the law applies when it doesn't. In the same way that the judge said that I was a privately paid attorney when I didn't take $1. This is just, when I point this stuff out, guys, I want you to know, remember, you're supposed to have a presumption of innocence until proven guilty beyond any reasonable doubt. You have none. You don't have it. The state is weaponized against you. They always have been, and prosecutors are pretend lawyers on easy mode. And I like some former prosecutors. I like Nate the lawyer. I like Emily Baker. They're really wonderful YouTubers. They're great people. I don't like prosecutors. I don't like what they do. I don't like how they do law. I don't like how the state supports them. I don't like the incestuous relationship they have with judges. I don't like any of it. I think it's garbage. But no, it had nothing to do with the relative attractiveness of my client and the judge. It had nothing to do with any of that stuff. It's just the way the day went. My judge has a particular issue with, and again, the decision of the judge, let's be very clear on this, was perfectly reasonable. That wasn't the problem. It was the berating of my client that was unnecessary. The moral grandstanding that was absolutely unnecessary. That's the shit that gets on. And you see this it's not this judge. It's all of them. Like, look, guys, go spend a day in traffic court. And you'll hear a judge morally grandstanding to some 16-year-old who gets a speeding ticket about how, you have to follow the law, young man. I'm going to give you the opportunity to learn from this incident where I charge you $150 plus this imposition on your driver's license, because you need to take a lesson in speeding. It's like, oh, fuck you, judge. Like you're not driving 75 in a 70. Stop it. Stop this shit. These judges pretend their shit doesn't stink. They pretend that from the bench, and it bothers me because they give these moralizing, grandstanding sermons. So, oh, you're a young man with a lot to live for, and I'm hoping that this jail sentence of 6 years in the state penitentiary will help you realize the potential you have. Oh, fuck you. You're putting a 22-year-old in prison for 6 years. Their life is over. You've ended it. You effectively, statistically ended any future potential they have. They're not learning from this. They're going to go to prison. They're going to meet drug dealers. And when they get out and they can't find an apartment and they can't get a job because they're labeled felons and they can't vote and they can't buy a gun, they're going to go to that drug dealer who got out 2 years earlier and they're going to say, hey, man, you need a mule or something because I don't know how to live. That's literally what you're doing. And if you're okay with that, that's fine. You can be okay with the incarceration for 6 years or whatever. It's not about that. It's about the moralizing, grandstanding bullshit from an ivory tower judge who will never face a single consequence in their life. They will never go to jail. They will never get a ticket. They will never get... Could you imagine a county judge or a federal judge getting pulled over by local sheriff? Like, you know why I pulled you? Oh, shit. Hey, Judge so-and-so. How's it going? You know what? Yeah, I'm just, look, you're a little above the limit, but I'm going to let you go today. These people are the epitome of privilege. They have you can't challenge them. You can't, unless they're literally have a dungeon full of dead children. You're not going to get them in prison. It's embarrassing for them to talk about privilege, to talk about opportunity, to talk about rehabilitation. They know nothing about it. These people have never faced a day of negative consequences in their entire life. That's why they're a judge. What judge knows about going to prison? Oh, I've sent a bunch of people to prison. I know all about that. You do not. You went to undergraduate school, graduate school in the form of law school. You worked as a prosecutor or whatever for a while. You got appointed or elected a judge. You got appointed by a governor to a job and then elected incumbent because no one knows about judges. Or you got elected to a judgeship for whatever reason. You've never even set foot in a fucking prison. And if you did, you were treated like goddamn royalty with the royal tour to look at the prison inmates as if they were zoo animals behind cages. Like, these people, guys, you don't become a judge if you have a history of consequences in your life. It's anathema to judgeship. You don't get there because you're like, oh, I was a hard lawyer who overcame my meth conviction. Nope. That's not how that works. You don't get elected to judge ever. These people have no concept in their entire life of a single fucking consequence, and they send people to prison for literally ever until they die. And when they do it, every single fucking time, without fail, they will tell that person about the gravity of their offense and how they hope they learn from going to prison to die for the rest of their life. Look, I hope you learn from this and improve and find a way to heal. You do not. You're sending them to prison forever. And if you're sending a young person to prison for 10 years, like, it's fine. Their actions may justify the 10-year sentence, but don't sit there and be like, I hope this is a lesson to you so you can never vote or own a firearm again. That'll be a good lesson to you. That's not what are you talking about? A 10-year prison sentence? Oh, they're not going to have a job for 10 years. They're going to lose their house. They're going to lose anything that they built up in their life will literally be gone. And when they get out, they'll be labeled with this thing. They'll never be able to get a job. They'll outside of maybe, entry-level construction or maybe security for Eddie Murphy or something like that. And then they'll go on. They'll never do anything in their life. You're condemning them to a life of poverty, which they might deserve. But let's not pretend that they're going to go out. Well, when you get out after 10 fucking years in prison, you can then complete your graduate degree and go on to be a NASA scientist. That'll probably happen. No, they're going to be sucking dick behind the fucking McDonald's dumpster, hoping to upgrade to the Arby's dumpster because that's what you condemn them to. At least fucking be honest and stop lying on the stand as if you have any idea what someone goes through when they get committed to the Department of Corrections. Fuck judges, fuck prosecutors, fuck everybody in their moral grandstanding. None of these people live the most privileged lives that you could possibly imagine, because if they didn't, they wouldn't have the job. Could you imagine a county prosecutor or a state prosecutor who has a history of heroin convictions or domestic abuse convictions? Of course not. You wouldn't want that person. That's not the problem. The problem is they act like they all have life experience because they've spent years putting people in prison. They think that imputes upon them knowledge about what prison does to a person. Fuck these people. Thank you for coming to my TED Talk. Dapper Wolf says Fauci funded puppy Minecrafting with taxpayer money. He did. Ian Max says cut to Doc Brown and Back to the Future. The justice system works faster after they abolished all the lawyers that judges desire. Canadian Hestan says, let's go, Brandon. Found out today that the Afghani translator I worked with was shot. Along with his family, I don't want to be a doomer, but I'm losing my optimism. Fuck. Sorry to hear that, buddy. Shot in Afghanistan, I assume, if you're still there. Angry Bainling says, great story, Nick. That'll be $450 per session. True. Johnny Olson says, don't touch that potato, Nick. You'll get some Reddit on you. Habit of Huda says, if learning video editing from scratch, where to start? Look, I don't know, get Blackmagic or one of the Sony products for free that you can get. Sony Blackmagic? I don't remember. Get one of the free products you can get first. And then if you need to upgrade to Adobe Premiere or whatever, just start doing it. Download some videos and start editing them. Just work on it. I mean, you can take a graphic design course. You can take a course in video editing at a community college, whatever you want to do. But otherwise, you can download the tools and just start literally learning it. I'm pretty sure you could learn video editing from a bunch of YouTube videos if you wanted to. I would if I had more time, personally. I don't. But if that's what you want to do, go do it. Start doing it. Even if you're going to take a class, download a fucking program and start doing it. We're not in the age. We're no longer in the age of education equals experience. We're going to very soon be out of the age where degrees matter at all. If you want to learn something, and Lofty Pixels said this. Lofty Pixels is the Quarterings meme smith. He was on Flashcast. He said this, and this is right. Nothing he learned in college mattered. Nothing. Everything that mattered for what he's currently doing, which is working for the Quartering and editing videos. He did on his own, and he networked on Twitter. What you need to learn if you want to video edit professionally is how to network on Twitter and how to video edit. And the best way to do that is to do it. Listen, there's a million YouTubers out there. A million YouTubers. I think he said use hashtag editor wanted or video editing wanted or whatever on YouTube or on Facebook and Instagram and Twitter. I don't know. I don't know about that, but I can tell you I hired an editor. Although he's mad at me right now, which is appropriate because I haven't talked to him to get things going. But a lot of YouTubers want editors. We need people to cut down live streams. We need to create more content, always more content. And the main thing we don't have is time, but we can create time with money to your time. There's a ton of YouTubers out there to do it. Get on Twitter, make videos, edit someone's videos for free. Just edit them. Say, hey, I noticed you don't have, all you have are live streams. You don't have, find someone with a high sub and view count to start, maybe, because that means they have the money to pay you. But all you have are live streams. You have no clips or anything. Here you go. Here's some clips I made for you. Do that. That's your resume. Don't send them something else, some other work you did. clip down one of their streams into relevant topics. Say, hey, I did this. I can do this for you. Would you be interested in talking? There you go. Ishailson says, what comes first, Vic appeals or Nick has the audio on for a clip first try? I had the audio on. I specifically shut down the sharing and brought it back up with the audio on. Fucking hell. FM says, Nikki, you are muted. We can't hear you. Stop it. Talex says, waiting to see a cat lawyer at this point. Get over it. Says, pastor and comics creator of Hybrids, Luke Stone, has been in the hospital for 2 months. Would you check his GoFundMe search? Luke has such a huge heart. I would love to get over it. Can you email me and remind me tomorrow when we cover this so I can cover it when more people are here to do so? And someone else asked me they sent me an email to share a GoFundMe about a guy who got the poke and then died of COVID a week later. Well, we won't talk about that. But his wife and kid have a GoFundMe as well. I will share that. I would love to share it. I forgot to do it today. I'm sorry. I did get your email. Crusader says, so how's the hearing going for Kyle? You'd say, great. It's actually going very, very well. The judge is consistently applying the rules of evidence, and that's the most important thing in a trial. Honestly, consistent application of the rules is the greatest gift you can give any litigant. Danny says, next prosecutor ploy is Kyle vaccinated. Malik Fox says, government got grifted by the electronics company. Nope. The electronics company just said, hey, we're going to do some stuff. And government said, here's all the money you could possibly want. All the money you could possibly want. Fractal Machine says, if you want this hearing to be even funnier, you have to keep in mind that Bob was late with his report. Masako Y says, got in a motorcycle accident today and had the bike stolen before I could tow it. Thanks for making such a shitty day a little bit better. Masako Y, don't worry. In 10 years, like what happened with Yellow Flash, they'll find your bike in a yard in Chicago or whatever. You'll be great. I'm glad you're alive, man. Motorcycle accidents are very fucking scary. I'm sorry your bike got stolen, but I'm glad that you are alive. Cars in Depth says, did you see the piece at the Revolver about Ray Epps, likely Fed provocateur on January 6th? No, I haven't seen that yet. I'll check it out. Nintendo Power. Kyle prevented an act of terror and he's being treated like a mass shooter. Anyone comparing him to Baldwin is a tard. Absolutely. Automata says, I want to rent the movie Backdoor Hearsay. Look, starring Riley Reid. Mr. Bentham says, Trump voice, just a little arson, not too much. Frankly, it's mostly peaceful. If you were to ask me if I looked at it, if I analyzed this arson, I would say not a big deal. Not a lot of arson. I've seen more arson. Have you? Listen, I've been around a while. I've been to a lot of places. I've been to Detroit. Frankly, the whole town could use some arson. A little bit more arson in Detroit might help things move along a little bit. And it's not a criticism. It's really just, frankly, an assessment of Detroit and the state of it. Could use a little arson, if you ask me, but not a lot in Kenosha. Not a lot of arson. Super Iron Bob says, RE, the Supreme Court decision on cops pulling over for 1 mile over the limit. Now I understand the color of law. Thanks, Nick. Perfect. Tomorrow V says, does U.S. law include an assumption of telepathy between police force members? Literally, yes. Literally, yes, it does. It not only trusts them, it imputes them with knowledge that they don't have. Stellar J. Atkins says this judge is why they hate old white men. True. Wick Dipper says fire and a smirk. Crypto's chaos. Thank you for the donations. James Streisand says police and the justice system writ large have a few good apples. They do. Actually, I would say a lot of cops are good apples. I don't think it's a few. I really don't. The problem with it and with any government employee is that any bad apples are so devastating to the citizenry that it messes up the whole system. Naked Frame says, don't pile on Dizzy. Not his fault. He's tarded. Talix says, and that little rant is why you want Robert Barnes for your court of public opinion needs and perhaps not Nick. I'm not representing anybody in the court of public opinion, and hopefully not in the court of anything else for a while. I need a little bit of break. I don't want to be responsible for someone's liberty, and I don't want to be responsible for someone's family for a little bit. I've done that now for 5 years. 6 years? 5 or 6 years. I don't remember. I think I'm on year 6. I think this is my 6th year. I've done that for 6 years, and I want a little bit of a breather from that. It's heavy, man. It's fucking heavy. And I don't want the heaviness. I want the jokes. I want the levity. I want smiles. I don't want to be responsible for anyone anymore for a little bit, at least. Naked Frame says, this is Rosenbaum's son. That's why he's butthurt. Dizzy. Ryan79 says, F you, Dizzy. Digital says, Nick, we must entertain the possibility that Dizzy doesn't have an extra chromosome. He, she, it may, in fact, just be a masochist. Probably. Athena's Owl says, hey, a new subscriber. What's up? Hey, Athena, welcome. Welcome. Here is where you get a mix. Legal analysis, drunken rants. Oh, that one. Legal analysis, drunken rants, abject degeneracy, and a whole shitload of profanity and adult topics. Welcome. The water's warm only because you peed in it. The War Pony says, I was with you through those punishments up until you said eating Hardee's as a punishment. The breakfast is amazing. Unfollowed, unsub-reported. The War Pony, listen, you can like Hardee's. I like a Hardee's burger from time to time. Like even I have moral failings. Eating it every day, and that's your only food. Sorry, you would want to Minecraft yourself too. As Cyber, it's not about the Hardee's. I could have picked any restaurant on earth. You would not want to eat it every day. As Cybertaz says, see Kyle run, see Kyle shoot, see Kyle make it so Gage need help tying his boot. Lieutenant Hughes, welcome to paralegal status, Lieutenant Hughes. And this is a proper time for me to shill, not shell, Rekieta Media or Rekieta Law.locals.com, my locals page. That's where the best access to exclusive content and interaction is. RekietaLaw.locals.com. Go check it out. We should have some locals exclusive streams coming up very, very soon. Now that I'm done with this case, this past week has been a disaster because of the case. The week before was a disaster because of COVID and all, or the ban. And the week before was a disaster because of COVID. Look, we should have some locals exclusive stuff coming up. And that is the best way to get access to all exclusive content, because all of the exclusive content, no matter where it happens, will be available on locals, but not all of the locals content will be available anywhere else. Johnny Ringo says $5 says Bob isn't wearing any pants. Definitely not. Guys, when I'm on a Zoom hearing, I'm wearing a suit jacket, a suit shirt, a suit tie, and shorts at best. Wick Dipper says Bob's the only expert the prosecution can find willing to testify for them. Sometimes it's hard. The facts just aren't on your side. Facts just are not on your side. And again, my recent case is a good example where the facts just were not on our side, and we were left to the mercy of the court. Unfortunately, this court had no mercy. No mercy for my client. Mean Sarton says, of course it was late. Dojos don't run themselves. He's talking about Bob's report. Dojos don't run themselves, and someone has to sub as teacher for the billing and encoding classes over at the community college. Naked Frame says, have another drink on me. Bob graduated high school barely. We're 195 likes away from 2,500. If you get to 2,500 likes, I will hate you. Don't do it. Joel Reese says, good job, Jay. Grift that lawyer. And I don't think you will. I think you're embarrassingly unable to. But if you get there, I'll know that you're liars throughout the rest of the show. So don't click like. Malik Foxon. Shit. Where did it go? Where did it go? Malik Foxon says, rule number 1, don't trust the chat except me. Of course, that's true. Spencer Mosher says, I liked just so you drink some more. Cheers. That's the 2,000 shot like. It is now down. And I'm going to go down fast after that. Geode says, we're not trying to cause your liver to fail, Nick. We're just trying to help encourage you to numb the pain from the long stream due to Jay's lies. Ingrid Bainling says, Nick, in your email to the prosecutor, don't tell them pay up and gay boys. Exclusively in that order, no matter how you feel about them, don't. No, I won't. I'll be a passive-aggressive piece of shit in them. Philip Booty says, we want you to get drunk. So you pen a letter to the prosecutor that includes words like fags and gay boy and a new bar complaint. Guys, I forgot to mention this. I said this on Flashcast. After 2 hours, it literally doesn't matter what you say for monetization. That Flashcast from Saturday is monetized on the channel. It doesn't matter. After 2 hours, you can be like, faggot, 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 faggot. It doesn't matter. It doesn't matter what you say after 2 hours. YouTube just doesn't give a shit. They monetized it. Hilarious. Digitalis says, we don't hate you. We just want you to drink and forget about Bob. Never ending, always talking, gargling Bob. First, last, it does. It literally does. It just quits after 2 hours. That was my suspicion. It was confirmed to me when I got my recent ban. The community guidelines team says, after 2 hours, we can't provide you a quote. And I'm like, okay, so you stop. Look, you can still get a community guideline strike for what you say after 2 hours. If you're like Fauci loves men or whatever, you can get a community guidelines for it. But you will not get demonetized for what's after 2 hours because the AI does not review past 2 hours. Nothing does. Nothing at YouTube reviews past 2 hours except for community guidelines. But when they do, they can't hit you with a specific strike. The algorithm just says, strike this channel. They said something about the vaccine or the election or whatever after 2 hours. Gamer words don't get you struck. Gamer words are not against the term of service. Gamer words are against monetization. Those are separate. Monetization after 2 hours stops caring. That's why you can say faggot, 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 faggot. It doesn't matter. Look, I love trannies. Love faggots. Don't care. Don't care what you are. I literally, guys, I'm the most accepting person on the planet. I'm the best. I'm the most wonderful person. I love the gays. I love the fags. I love the gays. I love the N-words. I love the Jews. I love everybody. I love everybody. I've loved everybody my whole life. They don't care. They literally don't care after 2 hours. I don't know why those words matter. Cunt, 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 cunt. There you go. I love women. I love cunts. Cunts are wonderful. You love to lick them. You love to touch them. You love to put your pee-pee in them. Doesn't matter. Cunts are the greatest things on earth. They don't care. Cunt is a verboten word on YouTube for monetization. But after 2 hours, it doesn't matter because they stop caring. They stop reviewing. They don't care. Cunt, 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 cunt. It's just how it goes. It's just how it goes. I don't know why. Don't know why. I have no malice towards anyone in my life. I'll say all the slurs in the world. It doesn't matter because I don't actually hate anybody. I love everybody. You guys know this. 47 Ronin Gaming says, outrage mobs are LGBTQ 2+2. Are you mad? Want to join a group about it? You're LGBTQ 2+2. Remember that, folks. Don't be LGBTQ 2+2. I don't even know what that means. Cunt, 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 cunt. Cunt, 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 cunt. Cunt terrific. Cuntacular. Cuntesticle. Let's stop pretending that these words have any meaning to anybody other than what you give. Australians are like, I love cunts. I call my best friends cunts all the time. Why would cunt be a word that YouTube would get rid of? It's literally in the monetization thing. If you say cunt, not monetized. I say cunt all the time. It gets monetized. Fuck you. YouTube doesn't care after 2 hours. Cunt stream incoming. Here's my cunt. Wolfgang Deo says, hope your day has gotten better, Nick. It has. If not, then hope this $3.50 after Susan. $3 AS $3.50 after Susan, $5 before Susan. Cheers you up and you can buy some Parmesan. I have Parmesan in my fridge. I love it. I just found out that Parmigiano Reggiano typically has a rind that is really useful in lots of Italian cooking. But no one in my town sells Parmigiano Reggiano with a rind. No one sells the rind. And I'm like, oh, I love Parmigiano Reggiano, but they cut the rind off. Now I want the fucking good stuff with the rind so I can use it to cook in soups and things like that. God damn it. Tomorrow V says a judge in Australia vetoed vitamin infusion for a dying father. Asked my daughter, quoted Trump drinking bleach lie as a reason. Trump derangement syndrome has crossed not only borders and oceans, but has crossed into fake countries. 2397 likes. You guys cannot do 2,500. Don't even lie to me. Mandy Karavica says, Nick, we know you can do Kermit, Trump, Jesse Ventura. What is your best female voice? I promise not to share it with Drexel. I don't do a female voice while I'm drunk. I don't really do female voices. I really don't. I don't know what that would even look like. I don't know how to do it. I don't know the inflection. I don't practice them. Adam K says, I'm a bit behind on the stream. Just got out of work in the fake open air prison country. Thanks for covering this, Nick. Also going to show my Instagram. Act shots. AK shot ZZ. I do photography. Might as well shill. Guys, check out Instagram. If you have an Instagram. AK shot ZZ. All one word. Check it out. He does photography. Not mastered ultra handsome Jack says drunk Flash versus drunk Nick. Who would win? Probably Nick. Look, Flash would attempt to beat the brakes off of me, and then he'd read super chats for 17 hours, even though there's only 4 of them. I would call him a piece of shit cunt, and I would win. Wolfgang Deo says, bro, I upgraded to the White House dumpster. Ian Max says, does this mean your Twitch is going to be late? We're running Twitch. We're watching a movie tonight. You can't stop me from Twitch with super chats, you liars. You liars and cowards. Can't do it. We're going to watch a good movie on Twitch. There's a whole bunch of them right now. We're going to do it. Naughty 86. Just for that rant, have a couple $2s. Poorly Redacted says, circumstantial evidence suggests that your chat is comprised of roughly 2% furries. Do you have anything to say about this? Gas the furries, even the good ones. K-Cash 72 cent. No one important says, that kid's long gone and this old man is all that's left. I got to live with that. One of the best quotes from the Shawshank Redemption. TJ says, thank you for that rant about judges. You're 100% correct about that crap. I've been to prison. I know what it's like, and it sucks. No judge in America has been to prison. And that's a fact. I don't know if it's a fact, but I'm confident enough to say it is. Wolfgang Deo says, video editing. Movavi is decent. I also use Handbrake and OBS. Most of what you do at the beginning is clip. Post-production is a fancy effects. Look, if you want to be cool, just get Adobe Premiere Pro. Or whatever the Apple equivalent is. Joel Reese says, by the way, who's this Nicholas Rekieta Melinda talks about? Nicholas Rekieta Melinda talks about. We'll do Melinda tomorrow. Not that way. We'll cover Melinda tomorrow. It's going to be too late tonight. I wanted to break it up with levity, but instead I screamed at the camera. Very embarrassing. Very unprofessional of me. How dare I? How dare I be human with you? You're supposed to be a robot professional. Fuck these attorneys who have no clients. Fuck these attorneys who have no idea how to get a client. These law Twitter fucking faggots running around. Oh, I'm on law Twitter. I'm an attorney making $1 million a year. No, you aren't. If you were, you wouldn't be on Twitter. None of you would be on Twitter. None of you are using Twitter as a marketing program. None of you are using Twitter to attract clients. You're literally only using Twitter to shit talk because you have so much time during the day to do literally nothing. Nothing in your fucking lives. There is nothing in your lives. You're loveless, employmentless sacks of garbage with law degrees. I've met every single one of you somewhere. Oh, yeah. Oh, yeah. Lawyering's a tough racket. I couldn't make it. Fuck you. You didn't do anything else. You just sat around collecting government assistance and sitting on Twitter like a fucking bum. A fucking pathetic bum. And then you go on Twitter and you're like, oh, I make $400,000. You don't. You don't make $400,000 a year. You know how I know? Because lawyers who make $400,000 a year, guess what? They're not working on Twitter. They're really not. Unless they're marketing. Unless they're marketing on Twitter. Maybe that's the case. You have 5 followers. You don't make any money doing this. Your Twitter is completely useless. You don't even have your law firm in your Twitter account. You're not even marketing. You're sitting here tweeting 250 fucking times a day about inanities, about how much you hate Trump and how much you love trans women cock in your mouth. And you're going to pretend that you're a fucking attorney working 70 hours a week to make you don't make anything. Everybody knows that you don't make anything, but most importantly, you know that you don't make anything. I've met a ton of these people. I've met a fucking ton of people with law degrees who have never made anything in their life. It's a symptom of the law school system, which, by the way, law school system wants money. They don't care who comes out and becomes a successful attorney. They want to increase the base of tuition payers. That's the law school system's job. Their job is not to increase the amount of attorneys who are successful at the end of the day. It's literally, can we increase the amount of people who pay for our service? Like every business. So to pretend that you graduated from law school and that makes you somehow special, it doesn't. You're not charismatic. You're not an attorney. You're not anybody. You're tweeting 250 fucking times a day because you're sitting on a toilet in a homeless shelter. We get it. It's fine. It's fucking fine. But that being said, nothing you say has any relevance on anything. And I'm so fucking tired of pretending that these people matter. If you're an attorney who's successful, put your name behind your opinions. Otherwise, you're a fucking pussy, and we all know it. You have a right to be anonymous. But why are you anonymous if you're on Twitter as an attorney? If you're not on social media as an attorney garnering business through your social media, you're an idiot. If you are on social media anonymously providing opinions, but you're not publicly an attorney, you're not literally grifting what you're doing, you're a fucking idiot. No attorney who's making $500,000 a year is bothering with Twitter, or they're making $500,000 a year because their law firm is promptly displayed in their fucking Twitter. And they're using that. Like, you look at Harmeet Dillon, you look at Ron Coleman, you look at, as much as I don't like him, Jay Woolman, you look at Mark Randazza, you look at Robert Barnes, you look at Viva. Viva doesn't do a bunch of legal practice. You look at these people who have successful legal practices while being on Twitter. There's a reason their name is public. Ron Coleman, 150,000 Twitter followers. Ron gets a shitload. I bet Ron gets a shitload of business from Twitter. Same with Harmeet Dillon. There's a reason your names are attached. And there's a big reason your names aren't attached. And you get to make claims that are bullshit. Fuck these people. Cars in Depth. I don't know where that came from. I don't even remember how we got here. Cars in Depth says Detroit was one of the few major cities without BLM, arson, and looting. Police Chief Craig wouldn't have it. He's running for governor against Whitlis. Good. Get rid of Whitmer. She's garbage. No one important says, also sorry I bombarded you with DMs. Hope the Fauci dogs, Netflix, Hypocrisy, and Worlds and Harem put a smile on your face at least. Look, I'm going to watch that Worlds and Harem when I get a chance. Tomorrow V says LGBTI or LGBTL equals let's go Brandon to infinity. Poorly Redacted says break beater 5,000. That's Yellow Flash. How the fuck are you guys 30 likes away from 2,500? What is wrong with you? Why would you do this? I clearly don't need a single other drink. Guys, I'm picking up a glass that I haven't even drank from tonight. I'm literally just picking this glass up out of habit now. This glass has not seen whiskey tonight. I'm just picking it up. I'm like, oh, well, whatever. Fucking glass. And you guys are over here clicking like recklessly, trying to get me killed. This is the glass. Motherfuckers, I don't need this in my life. I do not need this in my life. But rules are rules. And I am a man of rules. And it's as my friend Dan Fraga says, it's about, God damn it. It's about, shit, fuck. Oh, no. One moment, please. We're experiencing technical difficulties. Hold on, I'm just using this cloth to wipe a bunch of whiskey off my leg. I gotta clean it off my phone. Ah! It's all over my keyboard and desk and floor. There's no fixing the fucking floor. God. You notice I didn't drink anything, but we went from here straight to here. So just a second. There you are. There you are, you 2,500 like assholes. Asshole. You are asshole. It's all over my fucking desk. How embarrassing for me. Where's the pen? It's right here. It's right here. It's all over my leg. I'm going to just let my leg air dry because of the higher vapor point of fucking alcohol. Where? I'm putting the cork in this because I'm pretty sure we're not getting to 3,000 likes. If we do, I'll call 911 before I pour my shot. No way we get there. Literally no way. And if you guys get there, I hate you. Movie whiskey drink. I'm gonna drink this, but I'm gonna regret every fucking second. Yes, by the way, we are still doing Twitch. You can't get away from me. You can't get away from me. We're still doing Twitch. Poorly Redacted says break beater 5,000. Mr. Bentham says, I'm sure you will get to Twitch. Nothing can stop you. Well, I do have to walk upstairs to pee. Because I don't want to wait. My kids' bathroom is downstairs, down here. But I don't want to wake them up. So I go upstairs to pee. I do have to walk upstairs to pee and grab some food, so I could fall down the stairs and die. In a Rut says, insert gamer word. Have a booze Rackets. I have to drink the rest of this before the stream ends. Oh, by the way, I am trying to line up a full-on Grift stream on Twitch again. The last Grift stream I did was Raid Shadow Legends. This one will be Star Trek Fleet Command. And this one will co-star Lady Rackets. That should be, if we can pull it off, it'll be this week. Lady Rackets is a high-level Star Trek Fleet Command player. And she will be helping me figure out how to play this game. So, there you go. That's coming to Twitch. I've been waiting for Lady Rackets to come back on stream. We're also working on Die Hard movies by the end of October, because I don't know if they're going to go away. I really like her. I hope you realize I really like Lady Rackets. She's my favorite person on the planet. And I'm very glad to have her back on a show. I know you guys kind of like her okay too. Levi King says video analysis is very intensive. They're either saving money or have to split up the video and don't bother sending other segments. So Mr. Bentham says, Trump voice, 2.4 thousand likes. What a joke. Frankly, pathetic. Very embarrassing for you. Not a good showing from the chat. Next, he says, reminder, 40% of obese women believe they're slim. Wait, is that real? Is that a real thing? Angry Baneling says, Nick Rekieta declares Zergling was first on Twitch. Usually untrue. Viden the Cold One sent $1. Thank you. There's no message attached because it was $1. Andrew War Snowboard says, this super chat counts as 500 likes. Take another shot. I can't. Another shot would be devastating to my life. Thanks for the streams. I always love hanging out here and listening to the rage du jour, which is French for of the day. Anal. Because everything French ends with anal. Bonjour. That means good day. Anal. Je m'appelle Nick. That means my name is Nick. Anal. If I go, où est-ce que la biblioteca? That's where is the library? Anal. Seriously, every French, I've been through this language. Où est la toilette? Where is the toilet? Where's the bathroom? Anal. Every French thing ends with anal. I don't understand. I don't know why they're such a perverted fucking country, but they are. So rage du jour means rage of the day, anal. I don't know. They're fucking weird people. Poorly Redacted says, for future reference, how much do we have to super chat to get you to take a shot on command? At least $100. David Friesner says, I have nothing to say. I just want to support you again. David Friesner, thank you. Thank you. You guys make the show. You guys make the show what it is. I've said for a while, the show is the show. I will do the show as much as I can, no matter what. YouTube is a weird place. You never know who's going to show up to watch. You never know who's going to show up to send a super chat and support the show. YouTube does not like long live streams. They don't like them. This 4 hours of live stream, like I can't put ads on it and make it profitable. It doesn't work that way. It's not how YouTube functions. YouTube wants 10 to 15 minute videos. That's what they want. They want 10 to 15 minute videos from Blippi or Squishy or whatever. Some people exploiting kids. That's what they want to do. God fucking damn it, Laust Bulletz. That's what they want to do. That's how they make their advertising bread and butter. That's the shit they promote. By the way, we'll be soon covering Google's antitrust lawsuit brought by like 30 states, how they have a scheme to control advertising and manipulate it against the law. That's coming. But absolutely, YouTube does this. Absolutely, YouTube picks content that will manipulate and exploit their advertisers. That's a real thing. And if you didn't think it was a real thing, of course it was. There's too much money for them to not do. There's too much money combined with knowledge and technology for YouTube to not do this, even if it's accidental. Of course, YouTube exploits an AI to create a profitable advertising base that will extract more money from its real customers, the advertisers. You're not its customer, right? The advertisers are YouTube's customer. They're who pay YouTube to put things on their platform. You guys are not the customer. You're a function of exploiting the customer. YouTube loves that. We'll be covering that lawsuit very soon. But that being said, that being said, I lost my train of thought. Too bad. Let me finish this shot. I now have to pour another one. We'll get there in a minute. Angry Baneling says Lady Rackets is a hashtag no baller. Of course we like her. No, she's not. Don't lie about her. She's my favorite person. Frederick Little says, is Ray Gordon still going to sue you? Ray Gordon and his attorney never responded to me. Ray Gordon is a giant fucking pussy who's bad at chess. He's always been bad at chess. He lies to people about being good at chess. He tries to exploit people by pretending to be good at chess. Ray Gordon probably couldn't beat me at chess. He's a fucking nobody and an embarrassment. And by the way, I'm bad at chess. Ray Gordon is worse. Ray Gordon is the worst chess player I've ever seen on YouTube. In fact, I would shit on Ray Gordon's chess playing abilities, but he won't sue me because he's a fucking pussy. His lawyer is probably not even his actual lawyer. I think he spoofed the email address because he's a fucking pussy and he's trying to threaten me. He can't threaten me. Listen, Ray, you can't threaten me. Look, I'm a billionaire. I sit in Trump Tower. I eat these taco bowls, wonderful taco bowls, truly the best Hispanics working in Trump kitchens. You can't threaten me. You can't threaten me, Ray Gordon, especially not with your weak chess moves. You open with knight to queens 3. I don't even know what queens 3 means. You're a fucking pussy. You're fucking bad at chess. You're terrible. You try moving a pawn, but you are a pawn, so you don't know how to move them and you identify with them and you don't want them to die. They're pawns. They're irrelevant, just like you. Mr. Bentham says, omelette du fromage. Anal. True. Laust Bulletz says, best $100 spent ever. Take it, Nikki. Just a second. God damn it, Laust. Why are you doing those 60% alcohol whiskey? Curtis says, les enfants means children, anal. It's weird. The French are like that. Whatever we watch tonight is going to be a disaster that I won't even remember. God damn it. This is to you, Laust Bulletz. This is me debasing myself for $100 on the internet. 100 Canadian. This is me debasing myself for $35 fucking dollars on the internet. 100 Canadian. God damn it. Why does YouTube label $100 Canadian the same as $100 American? That's like saying, it's like saying 100 bullets are the same as 100 blanks. That's like saying 100 Alec Baldwins are the same as 100 Gary Plouts. It's not even true. Fuck this. Blaine 20 says, but potato instead of potato. Okay, got it. Malik Fox says, we like hashtag no ballers because they're adorable when they're wrong, though, like Bainling. Look, Lady Rackets is not a no baller. Stop it. What is this lies that he's spreading? Poorly Redacted says, $100. Rip your liver, my guy. Seriously. And I can't even get a transplant because I'm not vaccinated. Why would you do this to me? David Friesner says, I was one of the kill stream doxed bros. No, David, I haven't talked about this yet. Guys, very big news from Ethan, the fucking moron Ralph. Ethan Ralph just sent out an email to the Killstream.tv subscribers because Killstream.tv has been down for like a fucking week. Whatever. There was a giant security breach, by the way, on Killstream.tv or whatever it is. I don't know what his website actually is. Maybe it's Killstream.tv. I don't know. There's a giant security breach where all of the identities were easily identifiable. And so they've been trying to close that breach, apparently, with the company that Ralph hired to do this. And then Ralph sent out an email. More like 3 weeks. I don't remember. Guys, look, I legitimately don't follow Ralph. I don't know timelines. It's okay. I'm not trying to be precise here. Ralph sent out an email today. And instead of putting all 400 subscribers' emails in the BCC section, he put them in the CC section so they were visible to everybody. Ralph doxed 400 people through incompetence. Ralph, who shits on stream. Ralph, revenge porn aficionado, allegedly. Ralph, who marries pedophile trannies or whatever. Ralph, who can't take a fucking joke from Jay Dyer or anybody else. Fuck you, Ralph. Fuck you. You can't take a joke because you're a fucking beta pussy. You can't take a joke because you're a fat has-been who ruined his own career by being a fucking pretender. You pretended to be alt-right. You pretended to be for the white race for whatever reason while being married to a Pakistani woman. You fucking weirdo. Why did you pretend to be alt-white, Ralph? You're just a fat fucking dumpy nobody who happens to have a good ability to book guests. But you keep getting canceled because your own bad fucking decisions, your own stupid fucking mismanagement, your own inability. Look, I was sympathetic when Ralph got kicked out of YouTube. I really was. I don't think the kill stream should have been kicked off of YouTube. It should have stayed. Nothing in the heal stream was against the YouTube terms of service. It was all an artifact of a fucking faggot named Jared Holt. And Jared Holt has undue influence because he's a piece of fucking garbage. And he can't take a joke just like Ralph. Ralph is Jared Holt of the right. Ralph is Jared Holt. They can't take jokes. They have no humor. They have no consistency. And they have no principles. Ralph should not have been removed from YouTube, but everything after YouTube is on Ralph. Ralph was on free speech platform after free speech platform, and he couldn't make it. You know why? Because Ralph is a liar. Ralph has been a liar. Ralph will be a liar. He's just a liar. I don't know what to say about him. I don't know what else to say. He did this to himself because he got obsessed with trying to fix people who had negative opinions of him. Ralph, buddy, listen. And I mean this, buddy. I like Ethan Ralph. I've met him in person a couple times with a good chats. He's a fine chap in person. Online, he becomes a beta bitch. I don't understand it. I don't get it. I don't understand why anybody online becomes a beta bitch. Ralph, PPP, shoving dildos in his asshole, fucking shoving dildos in his asshole for fat, overage fucking weirdos on Discord. PPP, guys, if you don't know this, PPP allegedly is shoving dildos in his asshole on Discord for fucking overweight women in Louisiana or whatever. I don't know. What are these people? You know what I'm going to do? I'm going to go and I'm going to put a dildo in my asshole. What the fuck are you, Gavin McInnes? You're not Gavin McInnes. Don't put dildos in your asshole. What the fuck is happening? Ralph, ignore the haters or monetize them. Why? You're Ethan Ralph. You have a show. None of the people who hate you have a show. I don't hate Ethan Ralph. This is a fucking weird thing. This is a weird artifact product of Ralph's fucking mind. I don't hate the guy. I've met him a couple times. I've hung out with him. He's fun. He's nice. He's good. He's just a guy. He's a quintessential guy. You want to have a cigar with him? You want to have a beer with him? And then when he gets online, he turns from a guy into a labia. Why, Ralph? Why would you do this? I don't know. I don't know what's breaking him. I don't know what's broken him. He turned from a guy who's fun to hang around into a giant fucking pussy. Look, I don't endorse the guy's actions. I don't care what he's done in his life. I've defended people worse than Ralph. It doesn't matter to me. But he turns into a pussy online. Why would you do this? And so today, Ralph sent out an email to all of his Killstream subscribers, Killstream.tv subscribers. He just happened to CC all of them instead of BCCing all of them. So he doxed all of their email addresses. Ralph, hire a fucking professional to do your mass communication. Because what you did today was embarrassing. You compromised data security. You breached trust with your followers. And most importantly, the reason you did it is because you're being a consistent bitch online. I still like you. I want you to succeed. I want the kill stream to succeed. I think it's necessary. I think the Ralph Retort's a fine blog. Go do it. Stop being you. Stop being a fucking bitch. And by the way, stop lying about me and my life and my wife because you're insecure. You fucking faggot. You fucking pussy. My wife has never done anything to anyone to merit criticism. You want to criticize me all day? Go ahead. I don't care. You go after her. She's been nice to you in person multiple times without a negative word. She doesn't care anything about what any of you have done. You go after her because you're a fucking faggot who eats fucking dick and you drink semen, you fucking bitch. Fuck these people. Sorry. Had some things to get off my chest, apparently. So, look, guys, let me make some promises to you. You'll never find of me. You'll never find me pegging myself online. You will never find me shitting on someone's wife without her saying something like, Pantsu or whatever her fucking name is. I don't even remember. Being married to Digibro and supporting the idea of lolicon. Yeah. I'm going to stick with that. I'm going to stick with that assertion. You're never going to find me shitting on anybody outside of who they are. Right? Like, I'm not here to shit on Ron Toye's wife or kids or ex-wife or whatever. Shitting on Ron Toye because he's a piece of garbage. Shit on Monica Rial because she's a piece of garbage. Shit on Jamie Markey because she's a piece of garbage. I don't know anything about her husband. I don't care about these people. Shit on Dominique Sky because she's a piece of garbage. I'll attack you. Shit on Vito because he doesn't have any fucking love in his life. I'll go after you if you go after me first. Absolutely. 100%. Why would I ever not do that? I have no intention of going after people as an initial matter. I have no intention of going after people's spouses or kids ever. That's just not a thing I tend to do. The other thing you won't find me doing is shoving dildos into my asshole. I'll leave that to weirdos on the fucking internet. You won't catch me in a diaper. Okay. Will you catch me parodying Twitch thoughts on Twitch as a joke? Yeah, absolutely. Will I wear short shorts and a Sailor Moon t-shirt to grift a bunch of money as a joke? 100%. 100%. If you go on my locals, will you find me doing a nude hot tub stream? Yeah. You're not going to see my dick, you weirdos. You're not going to see my anus, you fucking weirdos. It's a joke. These are jokes. I'm in the hot tub. I'm doing a fucking joke because degeneracy isn't a joke. We can joke about degeneracy. These fucking weird people. I don't get it. I don't understand. If you're looking for some degenerate thing I've done, if you're looking to prove me as some sort of liar, grifter, guys, the worst thing I've done in my life is a blackface picture that was on MySpace. That was never intended for public consumption. It was for us and our friends who were there. Literally who were there to see me make fun of Drexel. If you're looking for some weird cuck thing or fucking anal dildoing thing, shitting on the toilet seat like a fucking embarrassment, trying to preach Bible studies while cucking to random 50-year-old Discord women from Louisiana, whatever you expect, guys, I'm just me. I've been online forever. I've been online a lot longer than I've been on YouTube. Just a guy with a family. There's no weird fucking shoving anal objects in for random Discord thoughts. There's no weird fucking cuck shit where I'm like, oh, no, that's degenerate. I think all cucks deserve either the cross or repentance. And I hope to bring them to repentance. I really do. I hope men. I was talking to Ty earlier. I want men to realize the value that they have and stop simping for women. Guys, you're not aiming above your value. You're men. You're not. This is a weird thing, right? Guys rate women at 9 out of 10 or whatever. Like, even fucking Angry Baneling is like, oh, look at Jen Psaki. She has red hair and big tits. She must be a 9. Jen Psaki is a 4 only because she's a redhead. She'd be a 2 if she was a brunette. Listen to me. Listen to me now. This is fucking important. Men, you earn the money. You make the decisions. She makes the sandwiches. She makes the family decisions. She helps manage the household. That's a good thing. That's okay. Women want to be in that relationship. They crave it. They crave the relationship where you go to work 8 hours a day and they stay home. They want it. It's their fucking dream to not go to work. Of course it is. It's the most logical dream on the planet. Men earn the money and lead the household. Women support the men because the men lead the household. That's how it goes. If you are in a household that is led by a woman, you have failed as a man. You have failed as a husband. Not that you have failed because she's strong-willed. You have failed because you are weak-willed. Be the man who leads the house. It's not demeaning to women, by the way. You go out and earn the money. You work 40, 60, 80 hours a week. You go do that. That is your commitment. That is your sacrifice. That is your provision. Then women come in and they provide something different. You don't want them to. Why would you want your wife working 80 hours a week? You don't want that. That means she's tired. It means she can't attend to you. It means she can't help you. She can't partner with you when you are home. Anyway, I'm fucking tired of these people. You will never find a video. You'll never find anything of me shoving a dildo in my ass. You may find that of PPP. Go look for it. Go figure out what the fuck is being said about PPP and him shoving dildos in his anus. Guess what? You're gonna find it about Ralph. If not today, you're gonna find it in 2, 3, 4 fucking years from now. You're gonna find Ralph shoving a dildo in his ass at the demands of Faith or Pantsu or whatever. Doesn't matter. Whatever ho du jour Ralph chooses, it will be him shoving a fucking object in his ass because he is not a man. Ralph is not a man. He hasn't been for a long time. It's a weird fucking thing. I like Ralph. I wish he was better. I wish these people were better than they are. I want men to succeed. I want them to realize the place that they have in society, and that place is as provisor. That place is as provider. There you go. Holy shit. That was a long fucking rant. It was a long fucking rant. My name's Elf. I like to eat cats, which means I eat pussy. Bad Vibe says Kyle's weapon identifies as a street sweeper. # cleaning the streets. Trooper FN 2525 says, don't pull a good logic, Nick. I'm not going to barf on stream. That's embarrassing. Although I am tossed. I am fucking tossed. And I have another shot to go. We'll get to that in just a minute. Angry Baneling says, the only race that matters is redheads. Facts, bruh. Look. I'm not married to a redhead. I don't have access to a redhead. They're their own thing. I love Lady Rackets fully. I love Lady Rackets covenantly. And I would never trade her for anything on the planet. I don't care. I don't care what she looks like. I don't care what she sounds like. I don't care what she acts like. I don't care what her opinions are. I don't know. This is, guys, you want Chad or trad Chad shit. 17 and a half years ago, I told Lady Rackets, no matter what, I'm yours and you are mine. I told her, I said, I don't care if you're fat. I don't care if you're sick. I don't care if you're dying. I don't care what your opinion is. I don't care if you turn into a lesbian. I literally don't care. My word is my bond. As a man, this is what you should care about. As a woman, this is what you should care about too, but I'm not talking to women. My word is my bond. I don't care what happens to Lady Rackets, what external factors affect her, what internal factors affect her. I told her, I promised her, I swore an oath before God. I said, you are mine and I am yours, no matter what. Thick, thin, health, not health. This is a thing that men don't understand. When you marry someone, you promise, you tell them, you fucking guarantee that you are there. And if your word isn't your bond, then what the fuck are you as a man? If your word isn't a bond, don't get married. Don't promise anything. Now, Lady Rackets is still very attractive. I love her. I think she's the greatest woman on earth, and I would want no one above her. However, if she was somehow lesser than what she was, but still, I promised to her, I said to her, I gave my fucking bond as a man to her. And if you don't value this shit, then you aren't a man either. Don't make promises you don't intend to keep. Don't be fucking Ralph. Don't be PPP. Don't be these fucking pretenders. Don't be these fucking bullshit beta males who have never had a real relationship in their life. Don't be these fucking gay garbage people. Be a man. Be a man. Or be a man and say, I don't. This is the converse of it, right? This is a Drexel of it. I don't give you my word. I don't promise to you. I don't promise fidelity. I don't promise faithfulness. I don't do this. That's okay too. I don't care. I don't care what you do. I know what I did. These fucking weirdos. You'll never catch me cheating on Lady Rackets. You'll never catch me with a dildo in my ass. You'll never catch me showing my ass or my penis on stream like some sort of fucking degenerate. Jokes are jokes. Reality is reality. Keep your sexuality in check. Your sexuality belongs to you and your spouse and no one else. Fuck everybody. Okay. Ingrid Bainling says the only race that matters is redheads. Facts, bruh. Look, I started this rant on redheads and then I got off the subject immediately. Redheads are the only category worth protecting. And again, Lady Rackets is not a redhead. I'm not a redhead. I have no interest in it. Redheads are a beautiful, beautiful gift from God. You should all love them dramatically. Ingrid Bainling says Jessica Biel in Texas Chainsaw remake is oh lordy. I haven't watched it. Oh shit. Poorly Redacted says rough day. Let's cleanse it with a 7th shot of 60% alcohol whiskey. This motherfucker, Poorly Redacted. I've been trying to avoid this the whole time. I'm gonna die. You're going to die from this. Okay, we've got, I think, exactly one shot. Ingrid Bainling says Jessica Biel and the Chainsaw Massacre remake is oh lordy. Did I read that one already? I did. Ginger Ninja says Kyle shows up to defend Car Source and interacts with police, then has his first interaction with Shoot Me Nibba Pedo was at another Car Source property, and Binger says the police statements aren't relevant. Look, Binger's a liar. Prosecutors lie constantly. I can't look. I've shit on cops on this channel. I've shit on cops constantly. Most cops are actually pretty decent. Probably 80% of cops are decent people. 0% of prosecutors are decent people while they're prosecutors. They may become decent people later. They may become better people. During their prosecutor status, fuck them. They're not good. Their job, it's not their fault. Their job makes them inhuman monsters. Fuck, I've got this drink. I don't know if I can drink it. That's going to be a mess. Spencer Mosher says Nick's going to have a massive hangover in the morning. Drink some water, dude. Lol. I will. All of Twitch is going to be propel in water. I'm already hammered. Why would you do this to me? Maybe Human says Dune was meh at best. Look, guys, I talked to my resident Doom pillar, Ty Beard, today. I texted Ty. He was asking me about something unrelated. So I'm not available. I had a bad day in court. He called me like a good friend to talk about it. We spent 95 fucking minutes on the phone. And Ty starts talking about Dune. He says, yeah, Dune wasn't actually good. The Dune movie wasn't actually good. He's like, I wanted it to be good. If you would have asked me the day after I saw it, probably would have said it's good, but that was wrong. That was wrong. Ty is not a fan. Not a big fan of Dune. Maybe I'll have him on later in the stream. I don't know. Poorly Redacted says, my dad instilled in me a phrase, a man has nothing if he doesn't have his word. Yeah, that used to matter. Our word and our bond used to matter. Doesn't anymore. Doesn't anymore. And it really should. Really should matter. Why would you want to go through life with your word not mattering? That's something I don't understand. Super fucking drunk. We're not watching fucking Tank Girl, Dawn Wanderer. Look, I'm drunk, so we're going to watch something with tits or something great. One of those two. Yorick says, Nick, you're the guy who gets blind drunk, throws up on the sofa, and Lady Rackets loves you more after cleaning up the mess. I've never in my life thrown up on a sofa. Always in the toilet. Because you yelled, get off me, I have a wife, while you were blacked out. Look, guys, this is a weird thing. I don't care what you think about Lady Rackets. I don't care what anybody thinks about Lady Rackets. I don't want anyone other than her. I'm not attracted to other women. Look, other women have slamming bodies, they have, whatever. I'm not attracted to them. I literally only want her. I promised before me, before her, before God, that she was the only person I would want. Literally don't care. I don't care. Primal urges or not. Look, I can recognize other women as attractive. What a fucking job. Can you imagine? Like, think about it for a second. Can you imagine all the fucking work it is to try and entertain some other person in your life? Fuck that. I don't want it. Don't need it. She's the only one I care about. Don't care. Don't care. Some super hot chick could come up and strip down naked in front of me and say, bang me. I don't fucking care. Fuck you. Go away. Go away. I don't want you. You're a waste of my time. Clown World says, well, to give some positive energy since the Seattle get together, I've shaved off the gun almost entirely. Losing weight at a great rate. Basically, your advice helps. Stop being fat and sweat out all the ice cream. God damn it. Pat Max says, you're lucky you haven't dealt with bitches nowadays. They're all hoes. That might be, but I didn't make a promise. I didn't make a promise to a 2021 chick. I made a promise to a 2005 chick. I have to drink this shot. It's going to be a mess. What a disaster. What a fucking disaster. All right. I'm going to drink this. I'm going to go to Twitch. I'm going to watch a movie. I won't remember it. Yorick says, Nick, my last super chat, it was meant as a compliment to your dedication to your wife, which is rare in this day and age. Cool. Sorry. I don't even remember it. And Poorly Redacted says, Nick, you have no idea how much I love my wife, Rakeda. Literally, you have no idea. And you shouldn't. It's not your business. It's not your business to know how much I love my wife. Ever. Ever. And guys, don't make it the world's business. It's between you and her. What are you doing? Everybody's out here online trying to appease other people. You make a promise to your wife and you figure out how to deal with it. Spencer Mosher says, don't get alcohol poisoning, man. F's in the chat. Look, I'm not going to get alcohol poisoning. At worst, I'll throw up. I don't think I'm gonna. I might. This is a lot. This is liquor that I don't need. This liquor that I don't need. And I will say with this, I'm not going to drink it on stream. I'm going to drink it on Twitch because I have to go to the bathroom. And I need a few minutes. All right, guys. Thanks for hanging out tonight. I will drink this on stream on Twitch. Just not going to do it on YouTube. Have a good night. Hope you enjoyed it. Peace. Peace.